Ah, yes.
We fixed on the 15th of September.
When?
15th September.
15 September. Okay. Item 5. Here we can send the United States. United States. United States adjourned to list on 15/9/2023. How much time? List after week is paid for by 11 council of the petitioner.
Item number 1 and 2.
So we can dispense of with the appearance of Mr. Saikia. We'll close this as in purpose since the appeal has been filed by the appellant. For Mr. Ayat Saikia, then the Midas Curie, item 2. And this be here on senior council and additional APB for the state. Additional APB for the state. The London Amicus Curiae has fairly pointed out that that in this jail appeal he was appointed as a amicus curiae, but the appellant has preferred an appeal of his own by engaging a learned counsel, which is registered as criminal appeal 285 of 2018. Next, this two appeals cannot be material for to challenge the impeached judgment and sentence. This the court is inclined to close this jail appeal. This appeal, and in futures, as the appellant has preferred another appeal. Okay, so item 2 is disposed of. Just a moment. The London Amicus Curiae shall be entitled to his usual fees. No. Okay. Yes. Yes. Two, 7,
2, 7, 12, and 13.
yes.
You expect the case to stay around 9:30 AM today on 5/10/14. The infamous brother-in-law Samsul 50 years, number so and so, was going towards emergency Bazar Alumni and heard Dr. Sri Sabina Yashmi on his accused they were on the He is not the witness to the incident.
What is the date of the assault?
5/10/2014.
Yes, please continue.
Evidence of PW 188. He is the brother of the accused. I know the accused. I know informant Sultan Ali also. The incident took place on 5/10/2014. This is Samsul Haq was my elder brother. Around 9:38 on the previous day of the Eid festival, my elder brother went to the Magusi Bazaar with his daughter Sabine. I was at my home and was just having my business. So he was not there. Then Sabine actually informed me over that accused Nurhaq was assaulting her father Samsul Haq with a sharp knife. I asked him to spot riding a motorbike and saw my elder brother lying on the road at a legal state. Arranging a vehicle, I took my elder brother to Mumbai for treatment. There, the doctor declared him dead. After examining, postmortem was done that very day. Police came and conducted the examination. Later, police arrested the accused. Exhibit 1 is the inquest report and exhibit 1 is Ross, I did not witness the incident myself. Some 10 to 15% had already assembled there, whether it is the PO. It is not a fact that the accused did not kill my elder brother. It is not a fact that I have witnessed false evidence in the court their sensitive of was my elder brother. So we appreciate the freedom that he was not there. We will 10 to 50% better. It is in the Washington, the daughter of the deceased is at PWP. This is Samsul Haq was my father. I know the accused. His name is Nurhaq. Around 9:30 a.m. on 5/10/2014, my father and I went to Democracy Bazaar on motorcycle for shopping. On the occasion of Eid, my father was drove the motorcycle and was riding below. We came across the accused at Alipur in Delhi. The accused coming from the pistol on a bicycle waved at us. Then my father stopped the motorcycle. Then, as my father asked the accused as to what has happened, the accused stabbed my father in his belly and chest with a sharp knife. Then we fell off the motorcycle. Then the accused again stabbed my father on his belly with a sharp knife. I raised the alarm. Nobody came forward to save my father. Many people were there and they were witnessing the incident, but nobody came forward to save. The accused left the scene after assaulting my father. The accused left towards the north riding his bicycle. My father someone called to the nearby pistol and kept lying there. Later, I took the mobile phone from my pocket of my father and dragged my paternal uncle Rustom Ali up and informed him of the incident, whereupon he agreed. He arrived at the team. Arranging a vehicle, Rustom Ali took my father to Mohammed Hospital, where the doctor declared him dead. My father expired at Mohammed the very day. Police came in. Police procedure pitch well. I used evidence in connection with this case earlier. There is a shop near the place of occurrence. The incident took place on the road at Alipura. There is a tea stall nearby. People were there at the tea stall at the time of occurrence. Supur Khan, the shopkeeper of the country, Raja, the many others witnessed the incident. A lot of people from there. I do not know the names of all the people. It is not a fact that the accused did not accept my father in the shop. PW3 not case 13, he is not a witness. I know both the accused and convicted. The incident took place around 9 to 10:30 some 6 months ago. Then I was doing work at Democracy Bazaar and I saw a lot of people had assembled at Alipur and had witnessed Sabina and Yashmin was crying. The bike was lying at the place of occurrence. Samsul Haq was lying in front of it alongside the road in a previously injured state that he was bleeding. Water was poured on the one. Many people have gathered. Later, the injured person had taken to Mongolian hospital in the vehicle. I learned from other people that the accused had cut him. I noticed injury on the person of the injured person. Later, I learned that Samsullah had visited his last death very day. Was I had reduced evidence in connection with this case earlier. I did not witness the incident. So he came to know about some other person. CW4 is page 15. He also did not say. I know both the accused and the complainant. The incident happened around 10 a.m. on 5/10/2014. At the time of the incident, I was at home. One, Mujamma walked told me over phone that the accused had slept Samsul with the dead. Just 15 minutes prior to the incident, Samsul had a talk with me. After that, he went away for shopping on the occasion of it, and I entered my house to have my meal. After that, Mujamil informed me of the incident. Over phone, I went upon a rushed to the place of occurrence and informed the brother of the deceased about it. We arranged the vehicle and took video Samsul to Mangolder Hospital after intimating the police about it. Samsul expired on the way before the bridge Mangolder. Later, police came and contacted the injured patient. Postmortem examination was done on the dead body and the janaza funeral was performed at night that very day. Exhibit 1 is the inquest report. Exhibit 2 is my signature there. Because I had reduced my evidence in connection with this case earlier. I did not witness the incident. I went to the place of occurrence after the incident had happened. I did not see the accused at the place of occurrence. W5 is the informant. It's also what a witness. I am the informant of this case. I lost the accused. I know the accused. The accused took place at the morning of 5:10 around 9:30 a.m. that day. Samsul Ali went to the market along with his daughter Sabina Ishmi on a motorcycle for shopping on the occasion of it. Accused Mullah coming on a bicycle from the East College, Panikwa shop, stopped the motorcycle of Samsul Haq and caused injuries to him by assaulting with a sharp down. Now we appear the again just down. He started previous injuries and fell down on the road. Later we could learn about it from one being informed by Sabina Ishmi over. We went to the place of occurrence immediately. Samsul passed away on the day on the way while we were taking him to Mongol Hospital in the exhibit 2 is this area, exhibit 2-1 is my signature there. Because I did not witness the incident myself, I did not see the accused person at the place of occurrence. It is not a fact that the deceased had attempted to stab the accused with the dead. It is not a fact that the accused did not assault Samsul. It is not a fact that I did not cause it. 6, he was informed. It's 19. I've known the accused from the day of the incident. The incident took place on 5th of October last year. Anwar Hussain informed me over phone that accused Nur Ali had cut Samsul Haq. The accused Samsul Haq on death on the road while the letter was going for shopping. I could not go to the place of occurrence. Going to his deceased house, I saw him dead. I noticed injury on in the person of the deceased Samsul Haq. I was coming from Bobeda when I was informed of the incident. I did not go to the place of occurrence on that day. I went there afterwards. I did not witness the incident myself. W7 is this page 21. Sequence to have seen the incident. I know Anthony Sundar Ali. I know accused Nur Haq Ali and knew this is Samsul. The incident took place about 1 year back, 5/10/2014. The accused killed Samsul. During even bride, I came out of the room and saw the accused assaulting Samsul. The accused caused injury to Samsul by stabbing him on his belly with a sharp dagger. On being asked, injured Samsul Haq told me that the accused had cut. But this is relevant because he stated that he was accused this is that Samsul expired in the hospital going to the assessment by the accused mind. I did not go to the hospital. Later at night, the death body of Samsul was brought up. At the time of the incident, Samsul's daughter was along with him. They were going to the market. Because my house is about 60 feet from the place of occurrence. Many people, including Hajara and Mamara, gathered at the place of occurrence. I do not know the names of all the people. It is not a fact that I did not state to the police that on being asked, Samsul had told me that the accused had cut. It is not a fact that I did not go to the place of occurrence. It is not a fact that the accused did not assault Samsul. PW 8 page 23, even Caesar witness, he also did not see. I know informant Sultan Ali and accused Nur Ali. I knew this is Samsul also. The incident took place on the previous day of Eid last year. I was at my home then. Gilbert informed me of the incident over phone. I went to the place of occurrence. I saw that some women were holding injured Samsul. On being asked, Samsul told me that the accused had passed. After that, I ran up the police station. The injured was taken to hospital before the arrival of the police. Later, I heard that Samsul had expired. Motorcycle of the deceased was lying at the place of occurrence on the road. Police is there. Exhibit 3 is the scissor list where exhibit 1 is crossed. I am the BJP secretary. It is not a fact that I did not state to police about Samsung telling me that the accused had coming. It is not a fact that the accused was not informed me. PW 9 would be the relation. He also did not witness. I know informant Sultan Ali. I know the accused and news victim Samsul Ali. The incident took place some 8 months back. At that time, I was at home. One Jamil Ali informed me over phone that the accused had cut Samsul. When I went to the place of occurrence, I saw something in an injured scene. The people were nursing the injured person. Police was informed over phone. The injured person was taken to hospital in a vehicle. But I heard that injured Samsul died on the way to hospital. That of this case. Many people assembled at the place of occurrence. I did not see the accused at the place of occurrence. I do not remember the names of the people who were gathered seeing the injured. I realized that he was not in a position to speak. So, this is relevant because the earlier witness said that he said that the accused was assaulted. It is not a fact that the accused did not assault Samsul. In period of 10 minutes, the daughter of the pistol owner, she also did not see this. I know the accused. I do not know the informant. My father owns a pistol. At the time of the incident, I was in the pistol of my father. Then hearing a hue and cry came out of the room. Then I saw that a lot of people had assembled at the place of occurrence and that the injured person was pleading for me. I saw the people pouring water on the head of the injured person. The daughter of the injured person was wailing and weeping. Later, a vehicle was added and the injured was taken to the hospital in that vehicle. I did not witness as to who has assaulted the injured person. PW 11, he also did not see. I know the accused. At the time of the incident, I was in my home. I was informed by the secretary of the BJP that a person had been back. Arriving at the place of occurrence, I saw that people were pouring water on the injured person and the blood was oozing out from the injured person. I knew the injured person, but I did not witness the incident. Later, a vehicle was added and the public took the injured person to the hospital. A lot of people assembled at the place of occurrence. Later, I heard that the injured person had expired. Of course, I did not see as to who had cut the injured person. PW cleared at page 31, but he claims to be a witness. I know the informant and the accused person, the injured. The incident took place on 5/10/2014. I was at London shop at the time of the incident. Around 9 a.m., Samsul came on the motorcycle. Then the accused wheeled him on the road and caused injury to him by dealing dagger. Samsul's daughter was also with him. Then the girl raised alarm. Whereupon many people gathered there and took Samsul to hospital for treatment. But he succumbed to his injury. I witnessed the incident. Cross Kanban Suba and I were at the shop. At that time, this was going towards the market. We came from the eastern direction, was proceeding towards the western direction. Police interrogated me. Police took my statement 2 to 5 days after the incident. There is a road to the north of the place of occurrence and Kenya's pistol and my shop was there to the south of the place of occurrence. A road and river was there to the east and a mosque and Akbar Ali's house are there to the west of the place of occurrence. The incident took place at Kalikua. The house of the deceased is to the east of the place of occurrence. I cannot exactly say how many people have gathered in the place of occurrence. I went home after the incident happened. It is not a fact that the accused did not assault Samsul to death. It is not a fact that the accused was not present at the place of occurrence. I do not remember the name of the daughter of the deceased. It is not a fact that I did not witness the incident. similar phishing case will witness. I do not know the informant. I know the accused person. The incident took place at 9:30 on 5/10/2014. I was at the pawn shop near the place of order. The deceased was coming on a bike at that time. Then I saw the accused laying Samson on the road and stabbing Samson in his chin. The accused stabbed the scene after stabbing him. Later, the injured person was taken to the hospital. Later, I came to the deceased at last time. Cross, my house is about 2 kilometers away from the place of occurrence. The incident took place in Kalipur. At the time of the incident, I was at the pawn shop. The pawn shop is situated near the place of occurrence. Nobody was along with me at that time. Some tea stalls are there near the place of occurrence. I do not know the name of the owner of the tea stall. There are road and schools to the north of the place of occurrence. Raku's shop is on the south. There are roads and
Just a moment, sir. Just. Yes.
there are roads and river to the east. There is a river to the west. I do not remember how many people gathered at the place of occurrence. It is not a fact that it is not a fact that I am accused for it. In the 12 and 13, they said that they witness. PW 14 he did not see. She did not see. I know both the informant and the victims. I knew this is function. The incident took place at 9 a.m. on 5/10/40. There are houses near the place of occurrence. Feeling a human pride, I came outside and saw the people pouring water on the head of the injured subject. Later, a vehicle arrived there and the injured person was taken to the hospital. Later, I could learn that the injured person is passed away. I could learn from other people that the victims had assaulted him. Ross, I did not witness the incident myself. I do not remember how many people gathered at the place of occurrence. I did not see victims at the place of occurrence. PW 15, she also did not see. I know both accused Blue Hawk and this is Samsul Hawk. I know the informant also. I heard the accused had after assault Samsul. I did not witness the incident, but after learning about the incident, I went to the place of occurrence. So Samsul Hawk, master lying in an injured state. That was losing out from his belly and chest. He fetched water and food stayed on the gallery, but I did not witness him being assaulted. Because I did not witness the incident. About 16 basically the Caesar witness to the bicycle. I know it was Europe in this is Samsul Rock. I also know the informant also. The accused left his bicycle in my house on the day of the incident. After that, the accused did not come back. I did not know whether where he has gone. Later, I came to know that he had killed Samsul. Later, police came into the bicycle. Police says that and I put my signature in this. Which point is very exhibit 4 is my signature. I do not remember the date on which the accused had left his bicycle in my house. The accused told me nothing about it. It is not a fact that the accused did not keep the bicycle in my house. I did not witness the incident. The 17 is also only considered witness. I know the accused. I knew this is Samsul Rock. Police seized the bicycle and need my signature in this certificate. Actually, 4 is the certificate and 2 is my signature there. Cross, I did not see the accused keeping his bicycle in the house of Krishna. To the circle officer, he contacted the investment. Now, what should we page 44? That is the doctor.
Yes.
Medical officer. Injury marks not at page 40 last part. One painting injury, 1 centimeter to 6.5 centimeters, 6 centimeters, 6 centimeters is present in the lower part of the leg. The On the injury sites, Sumanto is present left side of the chest, 3 centimeters of distance. On the injury sites, which is present 4 centimeters of injury. So we have 4 injuries. Opinion that is due to femoral and shock as a result of injuries sustained as well. All the injuries are equivalent caused by short contact object and
So that matches with the ocular evidence.
yes. EW20 is in the IO. It's 646. In 510 to 14, I was serving as ASI of police at Imatuji police. At the time, SI of police, Sugavan was on our OC Imatuji received telephonic information from BDP Secretary Kabir to the effect that group of night group open Samsung look at Kalikwa shot causing useless on the basis of the same information. Officer in charge reported TDN and our investigation. Accordingly, I proceeded to the place of occurrence and found 200 person together at the place of occurrence. I record the statement of the checklist. I seized the motorcycle of Samsung being found at the place of occurrence. Before my reaching at the place of occurrence, the injured was being taken to hospital. On the way to Mongol Civil Hospital, it is happened to a I prepared a sketchmap of the place of occurrence. Exhibit 3 is the seizure place in respect of the seizure of motorcycle. Exhibit 2, 3 is my signature. Exhibit 4 is the sketchmap. 4 is the picture. Sudanani, the brother of the victim, was the apparent GPS on the same day on 5/10/40. And about 2:30 p.m. Exhibit 2 is the serial file. On the basis of the serial file, the notice of case number so and so was registered by OC3 so and so. Exhibit 2 is the signature of said so and so. I am conversing the signature of the so and so. Recording the statement of the complaint Sujala and Sabina Ishwi, daughter of the deceased. I got the statement and said Sabina Ishwi recorded before CRPC by the minister. Executive issue had over the death of Samsung of the civil hospital. Postmortem of the deceased Samsung was performed to Mahmoud Civil Hospital. I collected the postmortem report. Exhibit 5 is the extent of the case number. In investigation, I examined the accused person and body chief judicial district. After the occurrence, accused was absconded and he surrendered before the district case. The body on 7/10/40. District message from the matter to the superintendent of police. The authority petition submitted by the accused expressing his willingness to surrender before the police. The case was taken to the case and there from I took the accused to the Imatuji case and was arrested. On the 4th, he was taken to police custody for 2 days. He confessed before me that he was infected with injury upon the victim, Samsung by means of an
In this case, the PP should maintain a rule of honor for the defense lawyer. Name of the defense lawyer must be in the rule of honor.
Actually, sometimes not at this trial stage and submitted by the high court. The duty of the case is to place it on record whatever is.
No, I'm not that.
Yes,
I'm not saying about the APP. I'm saying about the defense counsel.
yes,
His name should be in the roll of honor
yes.
because I have a feeling that when the other side is weak, that is if I am on one side and the other side lawyer is weak, then he's a great lawyer for me.
Yes, yes, yes.
Because at the people used to say that he's not a strong opponent, but I would always praise him and say that no, he's the best one of the best
Yes, yes.
I have got. So that is what I mean to say when I am saying his name is should be in the roll of honor. No cross examination anywhere. Because even from the solitary evidence, he can be convicted. PW2 and 7 saw it. So minor contradictions doesn't affect the merit of the what you call conviction.
Those usually no actions below the elections of the first. In fact, none of them have said that there was some alternative. What is the
No,
reason?
the evidence which has come is some witnesses, I don't remember the sequence. one witness said that there was a cycle in the tea stall. He took the cycle, hit the motorcycle, and then the motorcycle fell, and he stabbed this man. There's another version which says that he waited the motorcycle and then stabbed.
All the witnesses, so far the 2/7/2013 is concerned. They said, he was coming on a bicycle, he waylaid them.
No, but one said that he hit the motorcycle with a cycle. Then he fell down, the deceased fell down, and then he was stabbed. There are two versions, but these contradictions have not been brought, has not been exposed.
20 December examination.
2013 said very
No, I won't know, I won't remember in sequence because I did not, what do you call it? The idea was not to, what is it called? To make it by heart.
Yes.
It's just a basic overview. On the cursory reading, I won't take responsibility of what I'm saying because I did not go deep into it. Just a broad idea of what I'm looking at. Yes, please proceed. Don't be-
Always before me, that something of by means of a knife. It was that the police part will be placed where he threw the knife. After collision of the gun, but the knife could not be traced out. Yes, I seized one bicycle on being shown by the accused from all at the material time. The accused was riding in the same bicycle. The victim who was proceeding in his victim motorcycle. Exhibit 4 is the scissor list in respect of one bicycle.
There are three exhibit 4 in this case.
Yes. I collected the SCD from the Bomolo PS. On completion of investigation, I submitted the charge sheet number so and so for the offense considered. Boss, the then OC so and so recorded the VE number so and so. I recorded the statement of Kabir. EW Kabir did not state before me on being asked. Samsul told him that accused person inflicted injury upon the accused person. The PW7 Hamida Begum did not state before me that victim Samsul told her that the accused inflicted injury upon him. I have not prepared sketchment of the place where the accused led us, stating to have shooed away the knife used in the commission of the crime. I have not recorded statement of Lahi Oram and Suming Oram. It is not a fact that the accused did not make any confession before us to have inflicted knife blow on the deceased witness volunteers one send the accused for recording his confession statement under section 164 CRPC, but he declined to contest before the district. I found bloodstains at the place of occurrence. I did not collect the bloodstains from the place of occurrence. Among the PS may know whether they have since been wearing clothes of the deceased. It is not a fact that the deceased seized bicycle does not belong to the accused. It is not a fact that the accused in no way involved in
The seizure of the bicycle was from where?
from the it is below.
How is it?
It's no 39. No, it was
House of one of the witness.
Yes, yes.
Ah,
Yes,
right.
16.
Because this witness said that he came in a cycle, parked his cycle in his house, and then went away and did not come back.
Yes. And in fact, the PW17 is also a scissor witness. He said that I was there when the vehicle was the bicycle was seized.
Right.
In the Washington C, taking to page 54. Details in respect of the doctor, query number 22, page 54.
Yes.
He was asking what you can say with regard to the injuries and the opinion. I do not know the injuries, how the injuries were sustained. I did not commit this incident. I do not know what examination was done by the query number 23. I was stated in his evidence that he surrendered to the DC after the incident. What is the reply? I surrendered out of fear. Query number 27 at page 55. Do you have anything to say? I did not assault Samsul. I surrendered to the DC out of fear. Since the public went to my house with the intention of assaulting me, I surrendered to the DC to save myself. Actually, I did not trust Samsul. Being frightened, I surrendered to the DC. I'm innocent. What your lordship saying?
DC. He surrendered before the deputy commissioner. Okay.
He surrendered on 7/10/14. Super, ministry is 47, middle one.
Yes.
It is statement of the, high. Start with giving investigation. Rest is taken person according to so after the accused was exporting and he surrendered before the London district magistrate 7/10. So for the witnesses are concerned. Not saying that there was some altercation or the whatever something. Here excess of motive will be a so a relevant factor because all of a sudden why? There was no animosity because even the daughter or the family members, they never said that there was some sort of animosity between the this is at the in fact, he said that there was a time reflection. That is doubtful. Because one said it was not able to speak.
No, that there's a sequence there. You see, the second witness, when he gave that statement that the witness that the deceased was not in a position to speak, he said at that point of time that the accused was not there. That means there's a time lag between him and the other witness, because the other witness says that he saw him attacking. I saw the accused giving a dagger blow. I went there and he said that he has cut him. Shamsud has cut him. So that is what the sequence is. Because that point of time the accused was there. When the second one came, he was not there.
There is no question of that he did not explain. Anything but was his intention. That is what I'm trying to question. The probability of
Maybe he was needing some blood.
but in the probability 302 instead of probability 304.
No, for that it can't be 304 part 2. The absence of motive will not bracket it there.
None of them stated that there was some animosity or something. So what can be the reason? Person will not, kill for the sake of fun or something. Probably he did not have the intention. That is not very clear from the evidence, but at the same time.
No, unless you can demonstrate that absence of motive is absolutely fatal for the prosecution case.
It cannot be determined at the same time. Lordships, even otherwise. Because the procedure is to prove that now lordship will see that there has to be some motive behind. What was the motive?
Maybe the motives are many.
That can be presumed. That is what in a criminal case.
In a mental note, we can say that he wanted to lessen the burden of the Mother Earth. Too much of population exposure. We don't know. People have many motives. because this motive was interesting when when this US case of shooting at the mall that was there. And as per the newspaper reports, that he had no motive at all. He just disliked the race, and therefore, he disliked immigrants, and therefore he went to the shooting spree. That school also interesting thing happened. I think that school shooting. Yes. There's a case of 13 March 1996, Dunblane School Massacre. He entered the school, opened fire. Fifteen children died, and the motive was never ascertained. And you know why he came under suspicion? He was not caught. He came into suspicion because of his peculiar behavior towards boys. So that led to an inquiry, and then he was caught as an assailant. So he had some disliking for boys. But it is that for that he was traced out and then connected with that murder. Yes.
Only thing here, none of them stated that there was any there was no observation of what happened. What the that is what they said. Absolutely, whether the chief minister
Yes.
was left to be used, that was also never. Other people might not know whether there was any sort of quarrel or sexual intimacy. Only thing here, the brother-in-law, he deposed. His daughter deposed. They never said that there was some sort of intimacy between them, but what they had earlier they had a quarrel or something.
Yes.
Other than this, comes up.
You are relying on any case laws?
Otherwise,
Yes.
Here, your lordship, there are 4 numbers of IPs. PW2, PW7, PW12 and 13. And before one it is PW8, there is oral line declaration.
PW8.
PW8
Ah, right.
by the deceased, your lordship. Lordship, taking into account the evidence of record, most particularly PW2, who was very much there at the place of occurrence, keeping the doctor was in the pillion of the bike, your lordship. And coupled with the other evidence of PW12 and 13, there's nothing to disbelieve, your lordship, the evidence of the prosecution cases. The defense could have demolished the prosecution person, your lordship. And your lordship, regarding the motive part, my lord, may I rely on one judgment 2005, 13 SCC 353. Haji Khan versus State of Uttar Pradesh.
2005, 13 SCC.
353. 9.
SCC restored. SCC. Is it restored? Just. Paragraph.
Paragraph 9, madam. from the evidence of record, the Sessions Court and the High Court has rightly held that the prosecution has failed to establish the conspiracy theory and that the motive to commit the crime has not been proved, but does not mean that the High Court could not have convicted the accused, placing the reliance on the statement of the eyewitnesses just because the prosecution failed to prove the particular theory. We do not think so. It is not necessary that if the prosecution theory of the conspiracy or the motive fails, the entire case would crumble to ground. The High Court has found the version given by the witnesses trustworthy and found support to their statement from the medical evidence and lodging of the prompt FIR, apart from the fact that the appellant was apprehended on the spot or near about the spot of crime with the weapon which is used in commission of crime. When the court finds that the evidence of the eyewitnesses is true and can be relied upon, dislodge the prosecution of securing the conviction of the accused on the basis of reliable evidence. I have missed one line. When the court finds that the evidence of the eyewitnesses is true and can be relied upon, absence of proof of motive or the conspiracy to commit the crime would not dislodge the prosecution of securing the conviction of the accused on the basis of reliable evidence. Lordship, in this case also, the prosecution could not put there was some motive here, Lordship, but it could not lodge or dislodge the prosecution case, my lord. The presence of accused person, he was there, very much there, your Lordship. The PW 7, 8, 2, 12, 13, everyone proves, your Lordship. They were actually, although prosecution case doesn't say about their previous enmity or certified fact. Maybe some Lordship offense has taken place because of violating of the motorcycle, no? But it did not come on record, your Lordship. And the prosecution person, your Lordship, corroborates the medical evidence, your Lordship. Injury in the abdomen and the chest. As per evidence of PW2 at page 11, madam. Then, as my father asked the accused as to what had happened, the accused stabbed my father in his belly and chest with a sharp knife. Then he fell off the motorcycle. And the accused again stabbed my father in his belly with a sharp knife. Although the knife has not been recovered, Lordship, defect in the prosecution case, my as per submission, the prosecution could stand on its own legs, my lord. Lordship, your Lordship may ignore this part now, defect in the prosecution case. That is a respectful submission. Other side is informed.
61st. 61st. See. Hmm. Page 47. Judgment in high head, page 74. You have the informant. Let's just. But this Priya, this accused surrendered before the deputy commissioner.
Yes,
Deputy commissioner informed the superintendent of police,
yes,
and superintendent of police arrested him.
yes.
Caused his arrest.
Yes.
Who arrested, we don't know. But these arrest memos were never approved.
Shiv, your lordship will be, because your lordship is to go to trial court. This arrest memo was never been executed. Not executed.
No, but you see,
In the Assam, I'm talking about Assam.
no, that's okay. But here it's not a usual arrest because. Sequence 29. Of the two. It like the production of 29 makes sense. If you want to open, yes, this is- Like, I'm not think of it very well. Reason from you. Consider active on the listen. It will be not treatment in a clinical way. It is one. Hey, it is also not that he- I think that can be production on it. Yes, it's a bit. The piece of paper is also yes. This was a cut mark seen in the index value from the beginning. Injury. So,
Implementing measures of put to implementing measures of put to 1 which should be done.
Well, we find that many things are lacking, but since it was not taken up in the trial court, and those things are minor, but it is not fatal. So, few things you don't say. I'll tell you why this arrest memo I'm showing it to you. It will not be fatal. It will not be fatal, but still, it speaks volume of the lapses on part of the trial court as well as the um, defense counsel also. Prosecution did not know anything. You see the first flag. This is the order on production. What is the date? 8/10.
8/10/2014.
Next flag you see. This is the
7/10/2014. Forwarding the payers also required.
correct.
Yes.
What is the date?
This is surrender 7/10.
This is 7/10. So 7/10, he expresses willingness to surrender.
Surrender.
Yeah, the arrest memo. Next try is arrest memo.
8/10.
8/10, and therefore the order. Correct. Everything appears to be in sequence.
Yes.
Come to the second flag again.
Second, yes, sir.
Yes. Look at the date when the SDGM has seen it.
29/10.
How can it happen? Correct.
Yes,
Now
sir.
see the arrest memo. Look at the injury marks there. Cut injuries in the finger,
Yes.
index finger and ring
Yes,
finger.
yes.
This was never explained. In a 313 statement, the defense was not taken. We can't take it now. But look at the lapse.
Lordship, there is, my lord, but when judicial confession under the High Court rules, these columns are there. Any injury, how you got it,
No.
but it's there
You
is
see,
confession is taken of the.
if I accused is having an injury,
Yes,
it must be
Yes,
sufficiently
yes.
explained by the prosecution.
yes,
That was not done.
my lord.
That those defense were not taken.
Medical checkup is also done. 8/10.
So these injuries are there in that
Yes,
person. I'm saying it's not fatal. The question is, it speaks volume of the lapses which is
My lord.
occurring in the trial court.
Yes, yes,
Everything is being done casually. Because if the on the day of production, the note of surrender before the deputy commissioner was not there. The memo of the superintendent of police is not there.
yes. Only to OC, DKCPS for new Uttarakhand PS.
No, you
For
see,
national election.
no, this- no, miss, they have, you see, somebody expresses in his statement, he's saying that he got out of fear, he surrendered.
Yes,
So he surrendered before the superintendent of police.
yes,
But memos are not made there.
yes.
Deputy
No, no,
commissioner,
first, before the district magistrate.
so therefore, that's what I'm saying. Deputy commissioner does not make a memo.
Yes,
The superintendent of police does not make a memo.
yes,
Therefore, everything is being worked out in the periphery. There's no
Yes, yes.
entry anywhere
yes.
except for this statement.
Right.
And the accused says that out of fear I went there.
Surrender.
And then you put him into the hands of the police.
Yes.
What is the explanation why it has been given to the police?
Nothing is.
Nothing is there. Those defense will not never taken.
But my respectful submission would be, Your Lordship, in spite of all those taxes, since I count, eyewitness account is there, Your Lordship, which is, they're very much consistent. Your Lordship may rely on and opt in the conviction.
Yes, Mr. Prasad.
I don't think there was placed two decisions. Say that motive not moving or the motive is not. The first decision is Adam versus State of Kerala. There you go. According to the appellant, the prosecution has failed to establish the actual motive behind the crime. It is settled that when there is an eyewitness to the occurrence corroborated by other evidence, the non-establishment of motive behind the crime is not fatal to the prosecution. Motive intrinsically connected with the guilty conscience that's mentioned here, and it may not be possible for the prosecution to trace out the real motive behind the crime, invariably in all cases. Sometimes it may be known to the accused at home. When there is an eyewitness to the alleged occurrence supported by other evidence, and when it is found to be convincing and inspires confidence, non-establishment of the motive is not fatal. Frequent quarrel and strained relationship between the accused and the victim will improve for solution. It was lack of time. Hence, when there is a strained relationship or frequent quarrel, so it will satisfy the motive for commission of the crime. Another decision is made by the Supreme Court. I mean, give the citation of AIR.
Yes, that's fine.
Other decision of AIR 2023 SC.
Just a moment. Yeah.
AIR 2023 SC 193. This is from the Manipata citation.
No, I don't have money for that. Here I'll be having. Prem Singh.
Please. already known about it, it's paragraph 17.
And just. Yes, paragraph.
17. Above on heading of mental incapacity of the applicant. It's a heading leave of mental incapacity of the applicant. Just above. Okay, paragraph. Below. Down below. Taking all the facts and factors together.
There's something called motive and opportunity, conduct of accused, medical evidence, just pass me that copy, let me find it out. Same. Yes, para 17.
Yes. Taking all the facts and factors together, the chain of circumstances leading only to the hypothesis of the guilt of the applicant has been duly visualized and analyzed by the trial court, as also by the High Court. That being the position, learned counsel for the applicant has endeavored to submit that an important link in the chain of circumstances, that is motive, has not been established, and in that regard, reliance has been particularly been based on the statement of the wife of counsel, who did not support the allegation about strained relationship of the applicant and herself. As noticed, motive, when proved, supplies additional link in the chain of circumstantial evidence, but absence thereof cannot by itself be a ground to reject the prosecution case. Although absence of motive in a case based on circumstantial evidence is a factor that weighs more in favor of the accused. In this case, there are 4 eyewitnesses. It is not a case of circumstantial evidence. That there we have to presume that whether he was the last seen person or so. Here there are 4 eyewitnesses, 2, 7, 12, and 13. They have seen him killing. So the point of motive would have been an additional ground in favor of the prosecution. However, if it is not placed, it will not be valid.
No, we don't intend to reserve the judgment.
Just the allegation. Like my sister-in-law, that when yesterday she had to take a major accident, she's under this opportunity in the hospital. I could not go through the interview. But at the same time, I just what she might have done, because the conviction cannot be sustained on the basis of each and parts. It has to be very, in the case of the I was just going to base the decision. Mohammed Rafi versus Kullu, by the state of Madhya Pradesh, passing below criminal appeal 856 of 21.
No, what is the name, Mohammed?
Mohammed Rafi alias Kullu, state of versus state of
MDs or MOHD?
MOHD. Mohammed Rafi RAFIQ
versus
state of Madhya Pradesh. Criminal appeal number 856 of 21.
Just a minute. No, it's not available. Yes, please proceed.
In a murder case, absence of motive and animus indicate punishment not under section 302, but under 304 part 1. So, there, in fact, there are even other decisions as well. 1976 4 SSC 380, 2006 11 SSC page 444. So the only thing because of that, unfortunately incident went to the
What is the SSC, Sarjan?
one is 1976 4 SSC 380.
382.
1976 4 SSC 382, and the other one is
No,
2006.
one by one.
Close. Probably paragraph 12.
I think this judgment came to the help of that Navjot Singh Sidhu. Here, what had happened was there was a political this some political event going on, and there the accused was hit by a fist blow. So in that aspect, the court says, Supreme Court says that 76 judgment, clause B of section 299 does not postulate any such knowledge on part of the offender. Instances of cases falling under clause 2 of 300 can be when the accident causes death by fist blow, intentionally given knowing that the victim is suffering from an enlarged liver on an spleen or diseased heart. Such blow is likely to cause death. If the accident has no such knowledge of the disease special frailty of the victim, then it is not amounting to murder. Because then it has to be brought into the exceptions of section 300. If you can show us any exception that it will fall within the within 300. Exceptions of 300 or 299? 299. Except in cases herein after accepted, although murder, firstly, secondly, thirdly, fourthly. So you have to bring within that restriction.
But for the defense is concerned, the other decision which was 611 SSC page 444, paragraph 29.
Page 444. Just now.
611 SSC.
Just. Yes, what is the citation? 19?
2006, 11 SSC 444. Paragraph 59.
Yeah.
29. The court should proceed to decide the question of injunction.
But see the second last paragraph. Tentative order we are passing will give you liberty to show us any citation by tomorrow. Since you are saying that somebody is hospitalized, we'll give you that liberty, but tentative order we are dictating.
Worship Mayor, I must issue regarding the investigation. 2017, 13 SSC 19.
What is that?
Krishna Guru versus State of Karnataka. There are 28, 30, 31, 22.
What does it say?
It is settled law that mere laches on the part of the investigating officer itself cannot be a ground for acquitting the accused. If that is the basis, then every criminal case will depend upon the will and design of the investigating officer. The courts have to independently deal with the case and should arrive at a just conclusion beyond reasonable doubt, basing on the evidence on record. And your lordship, para 30. Once there is a clear contradiction between the medical and the ocular evidence, which is not in our case, Mala, coupled with severe contradictions in the oral evidence, clear latches in investigation, then the benefit of doubt has to go to the accused. Then para 31. Going by the material on record, we disagree with the finding of the High Court that the ocular evidence and the medical evidence are in conformity with the case of prosecution to convict the accused. The High Court has brushed aside the vital defects involved in the prosecution case and in a very unconventional way convicted the accused. Then para 32. The court should always make an endeavor. Court should always make an endeavor to find the truth. A criminal offense is not only an offense against an individual, but also against the society. There will be failure of justice if innocent man is punished. The court should be able to perceive both sides, that is the prosecution as well as the defense, and in a considered opinion, the judgment of the High Court suffers from serious so and so with the prosecutor. But in our case, Your Lordship, there are consistencies in the ocular as well as medical evidence.
No, that's not the intention here. We are showing you to show that you see the arrest memo itself becomes
Yes,
defective.
that is defective.
So,
Your
therefore-
Lordship may overlook that.
Therefore, what happens is that if the arrest itself becomes doubtful, then the detention, is it not illegal? That's what
Your Lordship,
we are pointing out.
Take into account the
It's-
other evidence of
It's,
record.
it's not that we already said that this is not affecting a merit of the case. But these things we are pointing it out because as additional public prosecutor, it's your duty to inform the police administration that this is what is happening.
Yes, yes. Every case is with Your Lordship. So
Because
much
the arrest memo,
defects.
the arrest memo itself is shown before the concerned magistrate after 10 days, 20 days. What is the sanctity of that arrest?
of
That's the major flaw. Doesn't affect the merit of the case. These things you will have to point out to the police administration. This this appeal is preferred under section 374, read with section 382 CRPC against the judgment and order of conviction dated 30/8/2017 passed by the learned Sessions Judge Udalguri in Sessions case number 159 within bracket capital DU bracket closed of 2014, thereby sentencing the appellant to undergo rigorous imprisonment for life and fine of rupees 5,000 with default stipulation for committing offence under section 302 IPC. Next paragraph. The prosecution case is that the appellant restrained the deceased. The appellant restrained the deceased who at that relevant point of time was proceeding towards Dimakuchi, DIMAKUCHI market on his motorcycle with his minor daughter in front of a tea stall of Dinesh Rajbamshi within bracket PW11 at Kalikhola, KALIKHOLA, and assaulted him with sharp weapon, causing grievous injury to him. He was shifted to Mangaldi Civil Hospital, but he succumbed on way. the trial commenced after the committal proceedings. The learned session judge relied on the oral testimony of PW2, PW7, PW12 and PW13, who were eyewitnesses who had seen the assault. As well as the oral testimony of PW8, to whom the deceased before dying had told him that the appellant had cut him. Next one. The prosecution had examined PWs, VIZ, page 74. So and so, within bracket PW1, PW2, within bracket. And the following documents were exhibited. Same page, 74. So it appears that there was a three documents, three exhibits were marked as exhibit 4. Next. PW2, namely Ms. Sabina Yasmin, was aged 13 years when she deposed as witness, had stated that at around 9:30 a.m. on 5/4/2014, she along with her father had gone to Dimakuchi, Dimakuchi Bazaar on motorcycle for shopping on the occasion of Eid. Her father was driving the motorcycle and she was riding as a pillion. And they came across the appellant at Kalikhua Tiniali, Kalikhua Tiniali, And the appellant came from a tea stall on a bicycle and waylaid them, waylaid them. When a father stopped the motorcycle, not that, I said full stop, then father stopped the motorcycle and asked the appellant as to what happened. And the appellant had stabbed his father in his belly and chest with a sharp knife. And resultantly, both of them fell from the motorcycle. And the appellant again stabbed her father with a sharp knife on his belly. She had stated that she raised the alarm, but nobody came forward, although many people were there. And thereafter the appellant left towards the north, riding on his bicycle, and the father somehow crawled to the nearby tea stall and kept lying there. And thereafter she took out the mobile from pocket of her father and called her maternal uncle, Rustam Ali, and informed him about the incident. Her uncle took her father to the Magadai hospital, where the doctor declared him dead. Her evidence to the effect that the appellant had stabbed her father in the abdomen and the chest could not be dislodged during cross-examination. And moreover, her presence at the site of occurrence, the place of occurrence, could not also be dislodged during cross-examination. Hamida Begum, Hameda, Hamida Begum, PW7, has stated in her examination in chief that not only she saw the assault, but on her asking, the injured informed her that the appellant had cut him. Her evidence also could not be dislodged during her cross-examination. Only the first. Only the first. There was no hotline process. Comma 7, except that she had stated that however, in a cross-examination, she is confirmed. They said statement by stating that it is not a fact that she did not state to the police that on being asked, Samsul, then bracket deceased, had told her that the accused had cut him. And she denied that. She denied the suggestion that she had not gone to the place of occurrence. Yes, okay. Yes, okay. Ratul Dekar, RATUL Dekar, who was examined as PW12, has stated that he was in the shop of Chandan, CHANDAN, at the time of the incident, and around 9 a.m. the victim came on his motorcycle, and the appellant waylaid him on the road and caused injuries to him by giving dagger blows. He had also stated that the daughter of the victim was also along with him, and that the girl raised an alarm and people gathered there and took the victim to hospital, but he succumbed to his injuries. He had stated that he had witnessed the incident. His evidence could not be dislodged during his cross-examination. A similar statement was also given by a statement similar to PW12 was also given by Chandan Chauhan, CHANDAN, CHOUHAN, was examined as PW13. Who stated that at 9:30 a.m. on 5/10/2014, he was at the pawn shop near the place of occurrence and saw the appellant waylaying Shamsun on his road while coming on his bike and stabbed him and fled away. However, in his cross-examination, he has stated that nobody was along with him at the time, except for the said contradiction to the statement of PW12. comma. His evidence that he saw the assault could not be dislodged. PW8, namely Muhammad MD, Khabir KHA Biaya Ali was not an eyewitness to the incident. How he arrived at the place of incident after later on and saw some women holding the victim, and on being asked, the victim told him that the appellant had cut him, and thereafter he rang the police station. And before arrival of the police, the victim was taken to the hospital, and later on he came to know that the victim had expired. In his cross-examination, he denied that he denied the suggestion that he did not state to the police about victim telling him that the appellant had cut him. Therefore, his statement about the direct detention made by the victim or the deceased could not be dislodged. So just take a break and come back. Out of the other witnesses examined by the prosecution, PW1, PW numbers 1, 3, 4, 5, 6, 9, 10, 11, 14, 15, 16, and 17 are hearsay witnesses who did not see the occurrence. This you can add, not in the same paragraph. However, the PW numbers 4, 5, 6, 9, 10, 11, 14, and 15 had gone to the place of occurrence and saw that water was being poured on the injured victim. As per the examination in chief of Krishna Das Chauhan, CHOUHA, Krishna Das Chauhan, was examined at PW 16, had stated that he knew the the appellant had kept his bicycle in his house and thereafter did not come. And later on, he heard that the appellant had killed the victim of the deceased. Thereafter, the police came and seized the bicycle, and he exhibited the seizure list within bracket exhibit 4 and his signature thereof. First off. However, in his cross-examination, he could not say the date when the appellant has kept his bicycle in his house. PW17 is also a seizure witness who had proved his signature on exhibit 4. Mr. Howard, in his cross-examination from PW17, has stated that he did not see the appellant keeping his bicycle in the house of PW16. Next one. Nayan Kumar Pathak, NAYN, Nayan Kumar Pathak, was examined at PW 18, had stated in his examination in chief that on 5/10/2014, he was serving as circle officer, come executive magistrate at Mangalwadi, and on the said date, he had conducted inquest over the dead body of the deceased at 1:45 p.m. Which was held at Mangalwadi Civil Hospital, and he had exhibited the inquest report within bracket exhibit 1 and his signature thereon. He had stated that the inquest was held in connection with GD entry number 140 dated 5/10/2014. His doctor is PW 19. Sessions को 19 पे लिखा है. Judgment. Next one. The Dr. Manidip, MANIDWP, Ray, RAY, DECA, DEK, was examined as PW19. In his examination in chief, he had stated that on 5/10/2014, he was serving as senior medical and health officer at Magadha Civil Hospital, and he had conducted postmortem examination over the dead body of Shamsul of SHAM SUL of HOQA on that day in connection with Mangalore PS GD entry number 140 dated 5/10/2014. Respect to the external appearance and the injury found on the dead body, he had stated as follows. Page 59. Page. So in his cross-examination, he has stated that the dead body was identified by a constable C/360 Ataur Rahman, ATUAR Rahman, RAHMAN, and that he had not mentioned about the wearing garments of the deceased, and that he had not preserved the kidney, liver, and stomach of the deceased. Next, the eye of the case, namely Khagendra Hazarika, was examined as PW20. Stated in his examination in chief that the then officer in charge of Dimakush PS had received telephonic information from Khabir Ali, KHABIR, PW8, was the VDP secretary, that the appellant had inflicted knife blow on the deceased at Kali Khua Chowk, KALI KHOA Chowk, causing grievous injury, and that on the basis of GD entry number some mistake somewhere.
Case 93 exhibited GD entry.
Huh?
Is 93, Your Worship.
What is that number?
JD entry number 106, dated 5/10.
106. But then come to page 43 of the paper book. In chief, second last line, inquest was held in connection with GD entry number 140. Change it again. Much. Okay. My sister has given, she is aware. Because when it's sent for postmortem, another GD entry is made. She is right. One 106. Information was recorded by the officer in charge was GD entry number 106 dated 5/10/2014, and he was interested with the investigation of the case. On reaching the place of occurrence, he found 200 of the 300 persons gathered at the place of occurrence, and he had recorded the statement of PW9. Hamida, HAMEDA Begum. PW10. Sukur Khan, SUKUR Khan. PW15. This PW14 is Momena Begum, and at page 46, name is written as Mamina Khatun. They are same. And Mamina Khatun, MAMINA Khatun, KHATOON. This is the motorcycle of the deceased, which was found at the place of occurrence. He had stated that before he reached there, before he reached the place of occurrence, the injured had been taken to hospital for treatment.
Page 97.
I'm just trying to confirm the name, change in name. That's what I'm asking. And that he had succumbed on way to Mangalore Civil Hospital. So he had prepared the sketch map of the place of occurrence within bracket Exhibit 3 and proved his signature thereon. He also exhibited the sketch map within bracket Exhibit 4 and his signature thereon. He also exhibited the FIR lodged by Sultan Ali, brother of the victim, on 5/10/2014, which was exhibited as Exhibit 2. Exhibit 2. He also exhibited the signature of Durga Kinkor Sharma, DURGA KINGKAR, one word. Durga Kinkor Sharma. SARNA and his signature thereon. No, sorry, he put the signature of the organ. He had also stated that he got the statement of the minor daughter of the deceased recorded under section 162 CRPC by the magistrate, and that the executive magistrate had held inquest over the dead body, and that the postmortem of the deceased was conducted in Manodar Civil Hospital, and he collected the postmortem report he had executed. The Democracy PS GD entry number 106 dated 5/10/2014 as Exhibit 5 as well as the scissor list in respect of motorcycle within bracket Exhibit 4. One bicycle, not cycle, bicycle. Exhibit 4 and his signature thereon. So stop. He had also stated that after the occurrence, the applicant was absconding and he surrendered before the district magistrate, Udalguri on 7/10/2014, who in turn informed the matter to the Superintendent of Police Udalguri and forwarded the petition submitted by the appellant, expressing his willingness to surrender before the police, and accordingly the appellant was arrested. The appellant was taken to Udalguri police station. From where the state PW20 took the appellant to the Democracy police station and he was arrested. He had stated that the appellant has confessed before him that he had inflicted knife injury upon the deceased. He had also led the police party to the place where he threw the knife after committing the crime, but the knife could not be traced out. And that the bicycle seized. The bicycle was seized on the basis of on being shown by the appellant. In his cross-examination, he had stated that PW7 did not state before him that the victim told her that the appellant had inflicted injury upon him. He had stated that he did not prepare the sketch map of the place where the accused, where the appellant led them by stating sketch map of the place where the knife was thrown. And where the appellant had led them. He has stated that he did not record the statement of Lakhi, Lakhi, Orang, ORANG, and SOBEN ran. And he denied the suggestion that the appellant did not make confession before them of inflicting knife blow on the deceased. First, the PW 20 in his cross-examination volunteered to state that the appellant was sent before the magistrate for recording statement under section 164 CRPC, but he declined to confess before the magistrate. He also stated that he found blood stain at the place of offense but did not correct the blood stain. He denied that the seized bicycle did not belong to the appellant. Next, based on the oral as well as documentary evidence, exhibited in this case, the learned Sessions Judge overlooked minor contradictions in the evidence of PW 7 and 8 on the ground that their evidence, that minor discrepancy or variation in the evidence did not make the prosecution case doubtful, as there were eyewitnesses to the occurrence, and then their evidence lent AD&D and credibility to the prosecution version. Accordingly, on the basis of oral evidence and as well as the dying declaration, the learned Sessions Court, Sessions has held that the prosecution had been able to establish that the appellant had inflicted knife blow on the deceased, which resulted in his death, and accordingly, it was held that the prosecution had been able to prove the charge against the appellant under section 302 IPC beyond all shadow of doubt, and accordingly he was convicted. The appellant was heard on sentence, and accordingly the appellant was sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 with the false stipulation of further rigorous imprisonment of 3 months. Next. Third, Mr. Hardev Leonard, counsel for the appellant, and Ms. B. Bihar Lala, senior counsel, and additional public prosecutor for the state, assisted by Ms. P. Boran. Next, the learned counsel for the appellant had referred to the minor contradictions which appeared in the evidence of PW 7 and 8. Any other contradiction, Mr. Bay?
But to meet the statement about the deliberation,
Huh?
was not supported by others.
Which one?
PW8,
It was also submitted that the purported time declaration by the deceased before the PW8 was not reliable because
was not supported by others.
because PW9 had specifically stated during his examination that the deceased was not in a position to speak. Accordingly, something that the reliance on the purported dying declaration was not sustainable, and therefore the resulting conviction of the appellant was also not sustainable. It was further submitted that the prosecution utterly failed to prove any motive of the attempt to assaulted the deceased. It submitted that none of the witnesses, including the family members of the deceased examined by the prosecution, had not stated that there was any previous altercation between the appellant and the deceased. Accordingly, it is submitted that in the absence of any motive and because the motive of the appellant has not been proved. The conviction of the appellant under section 302 IPC was not sustainable, and his conviction was required to be altered to 1 under section 304 part 1 if not acquitted. First, in support of his submission that there was a requirement of the prosecution to prove the motive, and that in absence of such motive, the conviction be altered to 1 under section 304 part 1, the non-counsel for the appellant has referred to the case of Mohammed MOHD, Rafiq RAFIQ, the state of MP.
2021 NSC 706.
Which one?
Homework of this case. 2021 NSC.
Just a moment. 2021
2021 NSC.
10 SCC
706.
706.
06.
This Kerala, you are relying.
Lordship.
Kerala judgment, you are relying.
Was it by Haji Khan state of UP?
Dhara versus state of Kerala.
Kerala was related by the not informed.
MP Prasad.
Oh,
Your
Mr.
lordship also
Prasad.
heard.
हाँ,
This will be recorded.
Oh, हाँ. Forgot the record is- अच्छा, in the earlier Kerala below, herdsmen, they were also like also had Mr. B. Prasad, when a councillor paid for responding for the informant. Informant is a party here. For informant, respond number 2. Next one. Yeah, anything I have left out? No.
Can you give me the leverage of this thing?
No, that's okay. We'll give you that. But otherwise, have I left out anything? No.
No.
Next. The learned entity has submitted that minor contradictions would not disclose the case of the prosecution. Because in this case, 4 witnesses had the factum of the appellant assaulting the victim, which had led to grievous injury and caused instantaneous death while being, no, not instant, the cause is death while being taken to Magadai Civil Hospital. So we submitted that the said ocular version is also supported by the evidence of PW8 that to whom the deceased before dying, the victim before dying had named the appellant of assaulting him. Well, so you are also regarding this 1976 for SCCM
Yes, yes.
2006. Okay, I'll add that. It is. It is also submitted that minor discrepancy in the investigation will also not disclose the case of the prosecution on the facts of this present case, where there are eyewitnesses to the incident. First off, it is also submitted that the lack of motive, the failure on part of the prosecution to prove the motive of the appellant in assaulting the victim would not be fatal in view of the ocular evidence. On the 4 witnesses, i.e. PW 2, 7, 12 and 13, who had seen the appellant assaulting the victim in the said connection. You are relying on that,
2005 13 SCC 353, Haji Khan versus State of UP, para 9.
2005.
13 SCC 353.
Is coming at 2005.
13 SCC 353.
And this regard, that is based on the case of
Haji Khan versus State of UP.
Haji
HAJI.
Haji Khan versus State of UP. And others for 2005. 353. Two cases cited by Mr. D. 1976 for SCC 382 and 2006 11 SCC 444. This Mohammed Rafiq also you are relying. Mohammed
This particular segment of the should be competitive to 30.
MOHD, Mohammed Rafiq, FIQ, alias Kullu versus State of MP. In 2021, 10 SCC 706. Where was this cited? 2023, yeah, 2023 SC 193, Prem Singh, Mr. Prasad. Also. Next. The learning comes for the informant respondent number 2. By referring to the case of Prem Singh versus State of City of Delhi, AR 2023 SC 193. Has submitted that the ocular evidence of PW numbers 2, 7, 12, and 13, and the evidence by PW 8 regarding dying resolution of the deceased, factored together, completed the chain of circumstances leading to the hypothesis of the guilt of the appellant. So it is submitted that in this case, although there is, this is not a case of circumstantial evidence on which the appellant is being held guilty, but it is the ocular evidence which has proved the assault, murderous assault on the victim. So accordingly, it is submitted that as far as circumstances, motive merely supplies an additional link in the chain of evidence, but absence of motive cannot be a ground to reject the prosecution case. That's all.
Lordship, on your submission, the evidence of eyewitnesses corroborates the evidence of the doctor.
Oh, acha. So it is also submitted by the current counsel for respondent to as well as by the learned APP that the ocular evidence of the PW2 regarding the nature of assault corroborates with the medical evidence of PW 19, who had found one stab injury in the chest, one in the abdomen, and two in the abdominal region. Okay. Just this is the dictation order. Are they of the appellate? We are the senior counsel and assisted by Ms. Bora, counsel for the Indian Council, and Mr. B. Prasad, counsel for respondent to. Huh?
Mr. P. Prasad was appointed account.
Acha. Amicus curiae. Wanted on behalf of respondent to. Argument is clear, judgment is over. This book list was given for which, for what purpose? The book list of 5 cases. So once we return, we will not bother ourselves. Matters of first bench to take up first.
Yes. Well, actually, partner says I'll be taking half an hour.
Okay, I think. Yes, yes. Yes.
We can start it now.
Ah.
That your lordship has already got it in details, I'm not reiterating well. It's already there. Lordship has not come to know what it's saying. But what I can impress upon your lordship is that in this case, on going to the evidence of record, it transpires minus that the original version of the prosecution case, the genesis has not been gotten. Why this quarrel took place? Why this fight took place? If
we take the evidence of the eyewitnesses, your lordship will see that there are big variations. Right? After going through it, I can show you in a glimpse manner. If we go to PW1,
But, Mr. Kumar,
my
we had just chit-chat before coming here.
my
We are of the opinion that if at all the plea of minority has to be examined, then it would become a mandate under the Juvenile Justice Act to first have that decision taken. That is by referring it to the concerned district judge to make an inquiry about the age. So, will it be appropriate for us to go into the to hear the entire merit and then?
this is Division Bench matter on 2016 way back matter. It clearly says that way what your lordship is expressing. Claim of juvenility may be raised before any court at any stage, even after final judgment. Delay no grounds for rejection, and it should be entered into it. Yeah. I just listen.
So therefore, to go into the merit, because
That your lordship will take.
because Mr. Kamal, you tell us the procedural law. In fact, is it permissible for the court to give a decision on merit on this in respect of the other accused, and then segregate the issue of juvenility in respect of one? Is that permissible, or we should stop at this stage, have the inquiry made?
Well, I think first the issues to be decided by.
Huh?
Issues to be decided since it's a joint trial it was, and since it is a joint appeal hearing matter. So I think the first course will be to decide the
Juvenility.
is legal.
That is what our tentative view was.
7A Mendes decree. Last time we only added
Because
one.
I have the advantage of having a sister who has been an expert in the field. So
He has rightly pointed out.
Yeah.
And this decision which I have brought in matter by the division bench decided by Honorable CJ. 7A is not. So in this case also the plea was taken by the pointed out. Then it came to light that the inquiry will be required at the 7A. So this is our
Ms. Jan, just to interrupt Mr. Kumar for the time being. What do you have to say in this issue of juvenility?
You know, one judgment lordship can see I've given the list in the morning. That is 2015, 2005, 12 SCC, where it is said, after dealing with the issue that it can be raised at any point of time. Thereafter, Supreme Court said that the court can go into the merit of the case. And if the lordship decides to upheld the judgment, grant conviction, then in that case, lordship will call for a report. If a lordship finds that no case is made out, then need not. Lordship can see that judgment 2005 said 12 SCC 615. Paragraph 16 in Manupatra. Lordship is taking on 2005 12 SCC 615. In Manupatra, it is paragraph 16. I can tell the words that it starts with.
Mr. Sushil Kumar.
No, Shri Prabha Shankar Mishra, learned senior counsel appearing in support of criminal appeal number 710. Where the juvenile point was, this is just before few paragraphs from the last. It is last but 2 paragraphs. Shri Prabha Shankar Mishra, learned senior counsel appearing in support of the criminal appeal, Lordship got it. Apart from challenging conviction of appellant Mohinder Pal Singh on merits, which we have already dealt with, submitted that on the date of alleged occurrence, he was a juvenile. Now they have gone into the merits. Then thereafter that issue was raised. He was juvenile under the Juvenile Justice Act, and on that date he had not attained the age of 16 years. It appears that this point was not raised before the trial court or the high court, but it is well settled that in such an eventuality, this court should first consider the legality or otherwise of conviction of the accused.
But
And
go
in
down.
case, Doctor?
But go down.
Yes.
Few
And
lines after
in
that.
case the conviction is upheld, a report should be called for from the trial court on the point as to whether the accused was juvenile on the date of occurrence, and upon receipt of the report, he shall be sent to juvenile home. But in case it finds that the date of the report received from the trial court, he no longer continues to be a juvenile, the sentence imposed against him would be liable to be set aside. Reference to Bhopram, in which case grant of special juvenile, because here he is already inside for more than 3 years. So if your lordship holds that case is made out against him, then lordship can call for a report. And if lordship finds that no common intention at all, then because the juvenile people are Sanjay Bol.
No, just now. No? You are trying to say that supposing his sentence of 3 years is he served the sentence for 3 years, he can be acquitted
From the High Court itself.
From the
without
High Court
sending to
itself?
others. Yes.
on the plea of
After lordship decides that he is guilty, then lordship will call for a report.
correct.
And
Then what happens to his conviction?
conviction will be set aside. Sentence will be interpreted with. No, conviction, if the report comes, if your lordship decides that he is guilty and the report comes that he is juvenile, then of course the conviction has to be set aside and lordship can release him because 3 years period. That 3-year period releasing from High Court, I have a judgment where Mr. Mishra did as an amicus that I can bring. But here what I find is there are not only one juvenile, I found there are 2 more. Sanjay Paul, Nirmal Paul, Hare Krishna and Parimal. Lordship can see page number 75 of the paper book. I think so. 75 of the paper book, perhaps the one which I learned senior friend had already shown. 75.
75 is bigger than
Or Sanjay Paul. Sanjay Paul is 26 years, so he will be a juvenile. This one you have pointed out. Name what? Name what person? So 26 years in 2014. So he'll be 16 years in 2001. More, no, lesser. Because occurrence took place in 2001.
No, one.
Yes. And then 2014 he was 26 years. So he'll be juvenile. Sanjay Paul will be juvenile. Then 125 Hare Krishna will be juvenile. Apart from Nirmal Paul, 125 Lordship will see.
First is first is page
First is page 75.
75.
on 26/11/2014, we were said to be 26 years.
Yes. So good form. Then Nirmal Paul, of course, 105 that he had shown yesterday. 32 years in 2014, so around 15 years.
Date of occurrence was
12/6/2001.
12/6/2001. Will be 13 years then.
Then 105, Nirmal Paul. In fact, 4 of the accused persons,
No, just we got it.
Nirmal Paul is at page 105.
It's 32 years.
So minus 13 years
Hmm.
will be 9 years. Yes.
13 years, he will be 19. He'll be adult.
Will be 19 or 18.
He'll be adult.
He will be, Nirmal Paul will be adult. 105. He was 32 years in 2013.
So he'll be adult. Even 18 or 19, he'll still an adult.
Then Lordship will go to page 125, Hare Krishna. Hare Krishna Paul was 27 years.
He'll be minor.
He will be minor.
And he has also stated, I'm innocent and we were corrected in this case. At that time, I was aged about 14 years and I studied in Bhopal.
Yes, it's up to the minor.
Page
So that is page
115.
125.
Page 124.
125 is
No, my sister is saying,
125 it starts.
my sister is saying page 111 also.
115. Shibu
115.
is 25.
Siva Paul is already juvenile. He is
He is
Oh,
already
he has gone. Okay.
That has been taken into account.
125 Hare Krishna Paul.
27.
And 135.
150. 155, I am returning, that's what I wanted to know.
One more.
41 Paul at page 144. He says, at that time I was aged 13 years. I have studied in Govardhan and School up to class 4. When you think calculate it will be some 15 years.
That is page number.
Page 144. Because I was placing my clients. Statement. Indirectly, the plea was raised.
So three appellants could be minor.
This is page 144 is
41.
Parimal.
Parimal Paul.
No, I'm sorry.
This is also examined on 26/11.
Yes, same, all examined. All examined on 26.
So in any case, he says 13, but he is 15. Because his age is 28.
Yeah. There'll be 15.
Hmm.
In the,
15 or 14, half something.
or
like
what,
that.
in the range of 15.
So therefore, if we accept the ratio of 2005, 12 and 6615, we apply our mind on the facts and circumstances, we arrive at a decision that whether we will be entitled to acquittal or not, and then take a plea of what you call the juvenile. It will not be too taxing for us.
Yes, that is correct. But then Lordship need not hear it any afresh after getting the report. Because Lordship need not hear it afresh after getting the report, and moreover,
No,
evidence
No,
against.
no,
no. You see what happens, Rizwan, there are two things. Number one, somebody who looks smart, somebody who is smart. I am merely looking smart, but I am not. After some time to recollect what we have heard in a criminal appeal where there are this many witnesses, and
It's not possible for
see,
anyone.
no, I don't say that. Maybe you will recollect. Maybe Miss,
actually.
maybe Mr. Kamar, with the confidence Mr. Ahmed argued, I think he'll remember it for next 1 year. The amount of effort he has put in. Correct. But I am on the first category.
Your lordship takes up so much of cases.
Lordship is very humble in saying that.
No, it gets serious. He's right. It gets serious. It's not possible to handle. Except for some, you see some in bail matters. What happens is that there's some crime which is what do you call is ghastly crime.
Shakespeare.
For bail purpose matters, we just remember the small things. It is a ghastly crime. But if for normal crime, it's very hard to remember.
Because what I have seen in this particular case, Lordship will know that most of this case, where it is said in a case of group fighting, at least two witnesses should take same names in order to find out the similarity. Here, what I find is one witness had said names of one or two witnesses, two accused. One had said about one. So in these circumstances, moreover, I'll have to establish common intention. So perhaps this is not a case of clear upholding the judgment. So in a way, Lordship has to go to the overt act. Overt act, again, one witness saying about one accused person is also very risky in case of group fighting. We need to Lordship, because Lordship has already heard it.
Well, let's encourage it. We think in the fitness of things, we'll refer this matter to the distributor to have an inquiry made for respect of three persons whose name appears now as juvenile. Parimal Paul, Hare Krishna Paul, and page 75. Parimal and Sanjay. Huh?
Hare Krishna Parimal Sanjay.
The reason not to accept, not to follow this 2005-12 SEC, that it would be too taxing to hear the matter on merit, find out the nature of guilt of this, at least this three people, and then to refer it. Because in the process, we'll have to go into the merit of the other accused also. We can't read in isolation. But it will be a common exercise for all the accused persons. We are not saying accused A and then reading it. Then for accused 2, we'll again start reading it again. We are not doing exercise like that.
So if these people are minor, the entire judgment becomes vicious. They cannot be tried.
It could not have been tried. Mr. Kumar, we are proposing to have an inquiry made.
The 7A with the judgment which you have given clearly speaks on their plan.
Huh.
That's what that exercise is to be carried out, certainly thereafter we proceed. If the report comes somehow that they know they were not given it after making a proper, then we will have to take them as a normal accused person's matter and then proceed to the other matter.
And if they are declared as juvenile, then without going into the marriage structure, then I think.
So far they are concerned.
They are concerned.
Objection to suppress and please it will take care of it. And then the objection to suppress and please.
Very good.
Then people will declare,
Mr. Kamal and Ms. Jahan, in this record, we did not find anything except for the statement in the examination of the accused in 313 about their age. So we are proposing that we'll send only the photocopy of the form of recording examination.
it is not,
Huh?
it is not.
And arrest memo.
Arrest also we can find it because at that time actually the police will carry out the exercise.
Just take 2 minutes.
You can also know we can.
No, it's okay.
We are fine.
You can just note it down. Hare Krishna Pal, arrest memo, dated 12/10/2004. He's,
2004.
yes,
Arrest memo has to be 2001. I think the
One.
arrested me.
No, that was
Oh, absconding. Hare
12
Krishna was
2004. His age is written as 21 years.
for 21 years.
Yes.
Then he'll be only 4 years down the line, 3 years.
So we don't know,
18.
we are not calculating on the face value. Whatever is there in the face value, we are just saying it. We are not calculating anything. This Nirmal Paul,
Nirmal Paul,
oh, he's an adult. Nirmal Paul is an
Parimal,
adult.
Parimal.
he's not a margin of age. Nirmal Paul. He was 18 years or so. That can also be seen.
Hmm?
Nirmal Paul's case can also be seen because
no,
he's
when
at
the
the age.
police gives an age minus 18 minus, actually they are something 16, something 17. Because if it is only 18 above, then only the police can arrest. So they normally put the age as 18.
Oh,
No, that's okay. But even otherwise from our calculation, he's an adult. So we are not doing that exercise for Nirmal Paul.
Best part is that because the first time the accused says his age by on his own in the 330 state.
Huh.
The moment you come- Not to the audience.
I think I have to surrender to you only. Actually, found only one. Sanjay and
Parimal.
Parimal.
Lordship, I don't find out.
No, I may be losing my touch.
Because you didn't know.
I may be losing my touch.
And actually, this is case that it will be better if we go to the GR record.
There is a GR.
Yeah.
After the forwarding of the document. When they were produced before the court matter, they produced the forwarding.
Uh-huh.
Nirmal Paul is everything.
So yes, GR. But the first order sheet is there. They have been produced.
Then it will come forward. When the arrest memo round of forwarding matter. Normally name of the accused before for they have not written the date. Sanju Paul they have written 18 years. Original Paul they have written 19 years.
So all above 18 years.
Because if they don't make it above 18, they cannot arrest.
Oh, they cannot do.
So that's why they have inserted it in this forwarding memo.
So
That these accused persons or Niranjan Paul was 18 years and Orimal was 8 years.
Mr. Kumar, please flag that if you have to sign that.
One.
The warrant of arrest, there everyone is shown more than 18 years. Vipul 22, Pradeep 28, Sanju 18. Sanju 18, Porimal 19.
Orimal here it is 18.
Oh, yeah, 19.
There is a arrest memo.
Yes.
These are warrants.
In the meantime, we just dictate the order, Mr. Kumar.
Sure.
Just keep a watch. Yesterday's order sheet. Same council. Mr. Kumar, Mr. Amir. See yesterday's order. Same set of council. Mr. Z. Kumar, senior counsel, assisted by Mr. And Mr. Kumar, you were assisted by
I'm assisted by SC Biswas.
Huh?
SC Biswas.
Mr. S. Biswas. They are separate trials, Mr. Ahmed into and
Mr. Pallab Patuki.
and Mr. Pallab Patuki. So the format. No, I'm just telling him the format. This Hare Krishna Paul is in appeal number.
The appeal number 78,
Second.
2016.
And others also.
No, Hare Krishna Paul is single.
He's 78.
78 of 2016.
Okay, and this Sanjay Paul.
Sanjay Paul is
Sanju Palma.
15.
Is Sandra. Sandra.
They are two different people.
Sondarpal is a weak people.
Okay.
It should have been Sanju Palma. Sanju Pal is the accused in this case.
Okay, Sanju Pal.
Sanjay Paul is in 50 of 2016.
75 days.
50 of 2016.
16.
Yes, ma'am.
And this Parimal Paul is in
Parimal is
Porimal is probably 94 months.
Parimal will be 15 in here.
50 of 2017.
Appeal memo
Parimal is in, this one, I got the name. He is in 94, 2016.
94,
Of
2016.
2016.
Acha. Just fit this in appropriate cases. Huh? Just write the name Sanjay Paul, Sanju Paul. So criminal appeal 50 of 2016.
Yes.
Then Hare Krishna Paul,
78.
he's 78 of 2016. Parimal Paul, he's in 94 of 2016. Huh? In this appeals, write in the appropriate case. Huh? In Hudson's rule. In course of hearing, the learned counsel for the appellant has referred to the examination of the he's referred to the form of examination of the accused persons under section 313 CRPC. And it is submitted that the said appellant, namely Sanju Paul, was 26 years on 26/11/2014, the date of his examination, and accordingly on 12/6/2001, the date of occurrence, the appellant Sanju Paul would be 13 years of age. Next, probably go in different, different orders. Now just write in the second paragraph, you write the name, appearance Hare Krishna Paul. This is 78 of 2016. Huh? His age was on 26/11/2014. His age was recorded as 27 years. Therefore, on 12/6/2001, the date of occurrence, his age would be 14 years. Then third, 40 years, approximately 40 years.
Ages are approach, that's why I'm
Approximately 14 years. Then Parimal Paul in 94 of 2016, right, as on 26/11/2014, his age is recorded as 28 years.
His age is recorded
As 28 years. However, in the last question put to the said witness, he has referred his age to be 13 years on the date of occurrence. Nonetheless, even if his age was 28 years on 26/11/2014, on 12/6/2011, his age will be 15 years. Now write a common order. These are three appeals, 3 orders. Huh? The next is common order. So therefore, it appears that on the date of occurrence, the appellant above named appears to be a juvenile. First of all, in connection with the determination of juvenility of the accused persons, Mr. Z. As senior counsel, has cited the case of INRI, State of Assam and another, 2016, within bracket 5, bracket close GLT 252. It is submitted that the division bench of this court considered the various provisions of the juvenile justice within bracket care and protection of children bracket was Act 2000 as well as the provisions of juvenile justice within bracket care and protection of children bracket was rules 2007 and thereafter referring to the case of Abuzar, Abuzar, Hussain, Hossain versus State of WB, West Bengal, comma, within bracket 2012, bracket was 10 SCC 489, had observed that the claim of juvenility may be raised even after final disposal of the case, and the delay in raising the claim shall not be a ground for rejection. Next one. The Learned Senior Counsel has submitted that in the event the court enters into the merit of the case and finds that no case is made out against the juvenile was tried as an adult, comma, the court may proceed to this court may proceed to acquit the said offense. First of how, in the event the court is of the opinion that the said offense appear to be guilty of commission of the crime, comma, in that event, comma, by considering them to be a juvenile, comma, their respective trial has to de novo begin or the comments before the Juvenile Justice Board. Next one. The learned additional PP by referring to the case of Gurpreet Singh, Gurpreet Singh versus State of Punjab, within bracket 2005, bracket post 12 SCC 615. Has also endorsed the submission made by the Learned Senior Counsel for the appellate. That in the event the court finds that this was a case for acquittal of the appellants who were tried as juvenile, juvenile who were tried as appellants. In that event, no such inquiry is called for. But if the court finds that the said appellants have participated in the commission of the offense, and then the court may, then the court shall set aside the conviction and send the case for a fresh trial before the Juvenile Justice Board. Next. In the present case in hand, as many as 9 accused were tried together. And along with the present appeal, comma, 3 separate appeals by the co-accused are being heard together. Correct? Therefore, if the submission made by the Learned Senior Counsel for the appellant and the Learned APT is accepted, comma, the court would have to deal with the voluminous evidence and to examine the merit of the arguments advanced by the Learned Senior Counsel of the Council and APP for both sides. And then take a decision on the plea of juvenility. This would require enormous effort of the court. It should go in vain if the appellants above named are found to be juvenile. Therefore, comma, the court is of the considered opinion that as the plea of juvenility has been raised, it would be appropriate to have an inquiry made with regard to the in order to ascertain as to whether the offense opponent was a juvenile on 12/6/2011, or the date of occurrence. It would be appropriate that the learned sessions judge comma. The additional section just number 2, Kabul Metro Guwahati. Who had heard and decided the court which had heard and decided the trial of Sessions case number 437 within bracket K of 2011 should carry out the exercise to ascertain as to whether the appellant of the name was a juvenile on 12/6/2001. Next, in order to enable the state learned court to conduct an inquiry on the registration, either send back the trial court records and of the court to send photocopy of the not of trial court records, scan copy of the trial court record or and of the court, the arrest of the production memo of the in respect of the fee, in respect of the appellant government, comma, photocopies of the statement of the government appellant recorded in course of their examination under section 313 CRPC. Next, on receipt of the 2 copies of the this court along with the documents of the court, the additional section says number 2, complementary petition. Make an inquiry and return his finding on juvenility of the appellant agreement to this court. Just in order to make the inquiry, the state learned court shall have liberty to to examine any witness or to call for video call for the respective birth certificate, and in absence of any documentary evidence of birth, the date of birth, want to cause radiological examination of the ossification test to ascertain the age of the ascertain the age, their age. Yes.
The joining of the boards.
Joining the results. Yes.
And since he has also claimed to be in school, but actually school certificate is
So that's what in the absence of any documentary evidence of age,
then-
proof of age, then ossification.
According to section 94.
Yes. Rules.
Section 94, yeah. What's it, 59?
What are the restrictions?
And to take such other steps as we prescribe in the juvenile justice. What is the full name? Juvenile Justice
Care and protection.
Care and Protection Act 2015
Yes.
and rules framed thereunder.
No, section 94 provides for determination of
The
age.
age.
What are the certificates to be considered?
In terms of section 94 of the Act and rules framed thereunder.
2007.
In 2007 rules framed thereunder. No, not framed thereunder. And
And rules to 2007.
and 2007 rules.
So we'll have a white power.
Next one. List after 4 weeks awaiting report from the balance sessions. Additional sessions, there's number 2, complementary party.
To complete the info.
Before this slide, the said inquiry shall be, then the additional sessions, just number 2, complementary party shall make an individual to complete the process within complete the determination process within a period of 1 month, and thereafter send a report to this court. List after
Edit it after 1 month, 1 week.
List after 6 weeks, let's say, list after 6 weeks.
They should actually do the process within 15 days. It's given in
Yes.
section 94. But from the receipt of the order, I think. They should do the examination.
Not be possible.
No, but then
Possible,
it's given
Payment of 3%.
There are 3 persons.
There are 3%.
There are 3 persons, they may be different, having different addresses.
Let it
They have to,
don't go by strictly subjects. For when just strict rules become difficult.
I we don't difficult.
Because district judge has to do other work also. The court will not be occupied with only one job.
No, right. Yeah.
It will be.
We are saying preferably within
Up.
a period of 1 month.
That will do. I think your lordship has got a single.
Yes, I have, but I don't know the timing, I don't know. We become so dependent.
No, I thought if your lordship gets angry and goes in division, that single will be different.
And the proviso that is there with section 94, I'm just saying for example, provided that such age determination test conducted on the order of the committee or the board shall be completed within 15 days from the date of such order.
Not that. Direct.
Then you get an opportunity of appealing against the order.
No, fine. Nothing.
No, it's just. No, because this is 15 days is too impractical.
Within 15 days, determining age of 3 persons, 4 persons. And if those are not available, authentication. This will take time.
Because the practicality of it, in fact, they are so preoccupied otherwise. The burden of judicial work is so high, administrative work is so high. To expect 15 days report is something too much.
Item number 10.
On the last occasion, Lakshmi was putting a question that whether there is any citation. As I made a submission to your lordship, that section 27 perhaps leads to some sort of discovery. We will have some sort of expected exceptions above 25. There are what is that? And respondent. Respondent number 2.
It's okay, he is solving a hard.
I didn't get it. Today I will confine myself only to the citations. Should we kindly come to page number 8. 2 lines of the first paragraph. Here also, lordship, here it is a case where there was a robbery and there was a murder, and the jewelry was recovered from a shop, and one of the assailant, he during investigation took the name of some other accused who was arrested. So we have squarely covered it. But if I kindly come, may I just read it out? It is, however, argued that
You're reading where?
what you are reading, page 8
the second line from first. It is starting from it is however.
Second line, okay.
Second line.
Page 8.
It is however argued that in a case where the offense consists of omission, even the words where he had hidden them would be inadmissible as they would amount to an admission by the accused that he was in possession. There are, in our opinion, two answers to this argument. In the first place, section 27 itself says that where the statement distinctly relates to the discovery, it will be admissible whether it amounts to a confession or not. I am on that. Specifically. Now,
Yes.
now I will worship attention to the 313 statement recorded. Before that, I will raise before your worship one judgment regarding this 313. This is the judgment which we have. Paragraph number page 5, paragraph 20. The object of 313. The watches can be got. May I read it? The object of section 313 of the code is to establish a direct dialogue between the court and the accused. If a point in the evidence is important against the accused, and the conviction is intended to be based upon it, it is the right and proper that the accused should be questioned about the matter and be given an opportunity of explaining it. I am putting an emphasis on that. Now I
You're reading when? 22.
logic. Page 5. It is paragraph number 22, subparagraph also 22, last paragraph. It starts from the object of section 313. May I again read it?
Yes, yes.
The object of section 313 of the code is to establish a direct dialogue between the court and the accused. If a point in the evidence is important against the accused and the conviction is intended to be based upon it, it is the right and the proper that the accused should be questioned about the matter and give an opportunity of explaining it. So here the emphasis is on explaining it. Now, Lordship, kindly have a look to the replies given by him. Page number 94 of the paper book. Nine questions were put to him. Nine questions were put to him, Lordship.
Yes.
Apart from the question put in serial number 2, serial number 3, Lordship, in all statements, in all he gives replies, it is a false statement. How can he know if he has not participated in the overt act, whether the statement are false or statement are true? He is not denying that I do not know. In 3, he is saying I know nothing about it. In other, he is saying it is false. Therefore, a person will say it is false only when he knows what is the truth. So my submission before Lordship that there is no proper explanation, and therefore the circumstances against him, which the prosecution has established, can be considered against him. Now, what are the circumstances? I made a small note, but I'm very sorry. It's a hand noted note. Your Lordship, the circumstantial evidence are from PW7. PW7 Lordship, she stated that it was the phone of her deceased auntie which was recovered from one of the co-accused. So it is established, Lordship, that the phone belongs to the deceased person. This is the first thing which has to be admitted. Second, Lordship will kindly see PW9 stated that PW9 is the sister, Lordship. She had a conversation with the victim on the day prior. On that day, the victim said over phone that one Raju Ali along with a helper is going to come for taking measurement of making almida. So the name is very specific. Then your Lordship will kindly see PW15 Lordship. She stated that on 17/4/2020 at around 5 to 5:30 p.m. she saw a tall thin male boy going out of the victim's house. These are the circumstances which give some hints. Now, vis-a-vis if we read, actually I am remaining myself as Kashmir Singh's judgment, so she knows well. Kashmir Singh's judgment says that if a co-accused makes a confession, then on basis of that confession, the other co-accused cannot be convicted. It's a very weak piece of evidence. But if the circumstances are otherwise, then it fortifies the prosecution case. Here the circumstances are otherwise. Now I would want you to kindly see, this is important, that when the accused was intercepted, he took the name of respondent number instantly. So Section 6 of the Evidence Act and Section 5 and 6 of the Evidence Act will perhaps have the equivalent of the prosecution. Anyway, I'll say it will have the appearance case because Lordship, it was spontaneous. It was spontaneous. And then the judgment which I just made before Lordship, it says that such sort of statement, if it distinctly relates to the discovery, it is not saying Lordship discovery. May I make my submission? My submissions are subject to the correction of examination. These are my submissions. What I have understood from this, it says Lordship it relates to discovery. It is not saying it relates to discovery of any tangible or non-tangible item. It says it is relates to discovery. So therefore, a fact has been discovered that so and so was involved. And other circumstances, if you take, they give a single hypothesis that no other person other than this respondent number 2 can be involved in this alleged part. So your Lordship, on the last occasion, I have taken your Lordship, and Lordship has also taken the pain of going through the entire evidences. My submission to your Lordship that there are sufficient material whereby this honorable court may have a look to interfere with the impugned judgment of acquittal that has been pronounced by the court and may convert this acquittal to conviction. That is my submission.
We will close it. We have already heard you. Pardon me? Can you speak up? No, for the timing was this bench will break. There is a single bench which I have to take. So otherwise, his submission is already there. He wanted some time to give the citation on that he has given. Let's see. The submissions of Mr. E. Bhattacharya, learned counsel for the appellant, is concluded. Mr. J. Das, learned counsel appearing on behalf of respondent two, is present.
This was respondent number one.
Respondent number one, okay, respondent number one, and Ms. S. Jant and the APK are present. Argument to go, judgment is out. Continue the single bench there.
Lordship. Diploma. Matter is been stated in the
Mr. Talwar, anything you want to say?
Item number 6.
Those will be rolled over. Because I'm taking a single bench. Yes.
Lord, in this matter, my lord, senior counsel is a 10 surgery case. Due to certain personal reason, is to give the court mercies for today.
You see, this bench, we are taking up this matters out of turn. This is not the journal is not appreciated.
So, my lord, I complete my part.
Can you give whatever you want to say, you say it in the reply.
My lord. But so far as the first item is concerned, my lord, our submission with regard to that part is
No, you see, it leads to a different different issue altogether. How much time can I keep a matter parted? Then I have to release it. You just vacate the interim order and release it.
but our submission with regard to the first matter is complete, and the reply has also been submitted. With regard to JLD, the SIPL part is, my lord, pending.
No, whatever we.
Because my arguments are continuing.
Yes.
Let me complete. Because JLD may not have argued, I'm giving my replies. If something is left, we can very well, counter it. My arguments are continuing on the last occasion, Lord, I could not conclude it. So I'll conclude my argument.
Yes, you continue with your argument.
Yes. So, Lord, a brief recap of what transpired earlier, just to refresh my Lord's memory. In this very case, my Lord, the very argument of the petitioner was the very argument, my Lord, of the petitioner was in this case that undue favor was shown to respondent number 6. That after submission of bid, respondent number 6 was given an opportunity to furnish new documents and materials, on the basis of which respondent number 6 bid was found techno-commercially responsive. According to the petitioner at the initial stage, it was the petitioner's bid only which was found responsive, and the bid of respondent number 6 was not found techno-commercially responsive. The bid of respondent number 6 was found techno-commercially responsive only after giving him an opportunity of furnishing materials. Now, my lord, what I had argued on the first occasion was there was a level playing field and free and fair play in the joints. Both petitioner as well as respondent number 6 they have given that opportunity. Petitioner suppressed the material fact that the same opportunity was given to him. In this very case, total 10 bids were submitted. Total 10 bids were submitted, and out of the 10 bidders, 6 bidders, including the petitioner and the respondent number 6, they are given opportunity to clarify and submit documents on their shortcomings. So far as the petitioner is concerned, the
This
petitioner
part you
had
have already
no-
argued. This
Yes,
part you
but
have
just
already argued.
refreshing your lordship memory only. So far as petitioner is concerned, the petitioner had not submitted power of attorney and the board resolution, thereby not fulfilling the requirement of clause 3.1a of the NIT. Likewise, the petitioner had also not submitted the class 1 contractor registration certificate. Petitioner was given this opportunity. Similarly, so far as the respondent number 6 is concerned, the respondent number 6 bid was found wanting on one score, namely, in the case of respondent number 6, his EPF registration certificate, which he had annexed, was on the name of Brahmaputra Consortium. The requirement of clause 3.2b1 was the number. The number was required to be furnished. Now, the document which he had furnished, the number was there, but the name of Brahmaputra Consortium was shown, whereas the name ought to have been of Brahmaputra Infrastructure, which is respondent number 6. Now, I had shown the document to demonstrate that this was clarified. The name of Brahmaputra structure subsequently came, and the number remained the same. There was no change in the number. So, same opportunity given to both petitioner, respondent 6, as well as to 5 other bidders. Total 7 bidders were given this opportunity. So, there was a level playing field. And all other sequence of events I had shown, I had furnished the relevant documents to show that there was absolute fair play. There was no arbitrariness whatsoever.
You can last referring to page 225 to 226 and then 229.
Yes, yes, yes. Now, I guess one more thing, I clarify. The clause 21 of ITB may kindly be seen, page 58 of the writ petition, which deals with examination of bids and determination of responsiveness. Page 58 of the writ petition.
That you have already said.
No, this I did not. I just clarified.
21.4.
Yes, 21.4. There is one thing over here. The bid is substantial. When a bid is not substantially responsive, then it is substantially responsive. That point I am clarifying. Because this is argued by Mr. Kenchon. 21, examination of bids and determination of responsiveness. During the detailed evaluation of technical bids, the employer will determine whether each bid A meets the eligibility criteria defined in clause 2 and 3. Since shortcomings were found in respect of 7 bidders, all of them were given this opportunity in respect to clause 3, and which was clarified. B has been properly signed, C is accompanied by the required securities, and D is substantially responsive to the requirements of the bidding documents. During the detailed evaluation of the financial bids, the responsiveness of the bids will be further determined with respect to the remaining bid conditions, price schedule of quantities and prices, technical specification and drawing. Now, my lord, 21.2 is important. A substantially responsive bid is one. It defines what is substantially responsive bid. A substantially responsive bid is one which conforms to all the terms and conditions and specifications of the bidding documents without material deviation or reservation. So, my lord, when there is no material deviation or reservation, a bid is treated to be substantially responsive. Now, my lord, as to what is material deviation is very, very relevant, and which is defined over here. What is material deviation? 21.2a says, which affects in any substantial way the scope, quality, or performance of the works. That is not the case here. That is also not the petitioner's case. B, which limits in any substantial way the employer's right or the bidder's obligations under the contract. Again, that is not the case. C, this is very important. whose rectification,
No, please continue.
C, whose rectification would affect unfairly the competitive position of other bidders presenting substantially responsive bids. Without pausing here, I clarify, had it been the case that in respect of the 7 bidders who were given the opportunity of clarification, among these 7 bidders, had it been only the petitioner who was given such an opportunity, and not in the case of the others, then all of them had submitted the substantially responsive bid, I would have understood that rectification would have affected unfairly the competitive position. Competitive position here was not affected. Out of the 10, the 7 bidders were given the opportunity to clarify and to remove the shortcomings in respect of their eligibility, including the petitioner. So there is the question of rectification that would affect unfairly the competitive position. Nothing of the kind whatsoever. And D, which is consistent with the bidding documents. So none of it below is affected over here. 21.4 below I had already clarified. Now, my lord, straight away I will turn to the submissions I make. I have 6 broad submissions to make. Before I make submission, my lord, let me place the case laws one after another. My esteemed colleague will note down. I have the the case laws I am citing pertains to the scope of interference in such matters.
Yes.
But in any case, but one more thing I would clarify. So far as 21.2C is concerned, that is, whose rectification would affect unfairly the competitive position of other bidders. To my understanding, the expression whose rectification would affect unfairly the competitive position may pertain to the valuation or the amount or the quantum we put in our bid. To my understanding. If we give it another meaning, namely that any kind of removal of shortcomings or clarification, even if we give a broad meaning, then other explanation is there. That I was not the only one, 7 bidders were provided this opportunity. But to my understanding, rectification would mean rectification would affect unfairly the competitive position. Because the clauses provide for giving such an opportunity. Because I refer to 5.4.5 of the contract manual, which says historical documents, the documents which are very much in the existence when you submit your bid. In respect of those documents, if a clarification is sought, you can furnish the documents. This, to my understanding, would mean rectification would affect unfairly the competitive position. Means maybe changing of bid, the amount you are quoting, that kind of a situation would be material deviation. Furnishing of documents or clarifying in respect of the shortcomings or such an opportunity being given by an employer would not amount to rectification that would affect unfairly the competitive position. But in any case, over here, I was not alone, there were 7 others. In respect of 3 others, shortcomings were very, very serious. So such an opportunity was not given. So level playing field, absolute fair play. Now, the case law on the scope of interference. The first is Jagdish Mandal, I am referring to 2007-14 SEC 517. The relevant paragraph, paragraph 22. That I will refer. Paragraph 22, I just read. Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When power of judicial review is invoked in matters relating to tenders or award of contracts, whether my lord, I'm sorry.
No, it's okay because this is, we have read it so many times.
In that case, my lord, I will not. Basically, my lord, whether the decision is unfair, whether the decision is arbitrary, whether the decision is unreasonable, whether it is perverse, I ask myself, the answer is emphatic no. That is not the case over here. The series of case laws not on this very subject.
Because
You know, there's only one aspect. There's one particular judgment I will refer to.
no argument in the tender matter is complete without this set of judgments.
Yes, that is true. But only one judgment I will cite, a very recent judgment, 2023 SEC online, 671. This lordship may. Yes. It is yet to be reported. I got it in OCC or SEC online. The para 52 minute I will show for one purpose.
I think now this has come on the portals.
It has come in SEC digest because may not at that time when I took out the copy, it was in SEC online only. Para 52 only I will read for one purpose. 52 minute I read.
Just a moment. Yes.
Ordinarily, para 52. Ordinarily, a writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer unless something very gross or palpable is pointed out. And unless something very gross or palpable is pointed out, the court ordinarily should not interfere in matters relating to tender or contract to set at naught the entire tender process at the stage when the contract is well underway would not be in public interest. Initiating a fresh tender process at this stage may consume a lot of time and also loss to the public exchequer to the tune of crores of rupees. The financial burden implications on the public exchequer that the state may have to meet with if the court directs issue of fresh tender notice should be one of the guiding factors that the court should keep in mind. This is evident from a three-judge decision of this court in such and such. So, my lord, ordinarily, a writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer unless something very gross or palpable is pointed out. My submission is, my lord, in the facts of the present case, there is nothing very gross or palpable. This is a case, my lord, where even two opinions cannot be taken. There is only one opinion which is possible, namely level playing field and free and fair play in the joints. Then, my lord, other decisions also have shown. Now, my lord, there is one decision which I have not referred to in my list, which is in respect of the conduct of the petitioner. Now, my lord, in this very case, if we see the writ petition, my lord will notice the fact that the petitioner got the benefit of an interim order only because prima facie petitioner satisfied your lordship that an undue favor was shown to respondent 6. His bid was techno-commercially not responsive initially, but was made techno-commercially responsive because an opportunity to clarification was given to him. An opportunity provided and he clarified. Petitioner did not point out in his writ petition that a similar opportunity was also given to him, that he was equally not eligible in terms of clause 3 because of his not furnishing certain relevant documents. That opportunity was given. So therefore, my lord, it's a case of suppression of material fact by the petitioner. The fact which was suppressed was the material to the passing of the interim order. There were three, my lord, components of the failure.
Just one. Yes.
There were three components of this failure. One, failure to submit relevant documents under clause 3 of the NIT showing qualification for bidders. Petitioner did not fulfill this initially. Two, opportunity given by NHPC to furnish those documents. He did not state that petitioner was given this opportunity by NHPC to furnish those very documents in respect of eligibility under clause 3. And thirdly, my lord, the submission of documents pursuant to such an opportunity, that when opportunity was given, he furnished those very particular documents, thereby making his bid techno-commercially responsible. So therefore, my lord, suppression of this material fact is suppressive variance, suggestive falsity, we call it, suppression of truth, and suggestion of false statement. And my lord, That
You're
is why-
saying first is that he got an opportunity.
opportunity. So he did not furnish relevant documents under clause 3. Those documents were under clause 3.1a and clause 3.2 capital A within bracket C. Namely, power of attorney he had not submitted along with the board resolution.
Three,
And number 2, class 1 contractor registration certificate.
3,
3.1 within bracket score A of the NIT. That is power of attorney and board resolution. That is a requirement of clause 3.1a. 3.2 capital A within bracket C.
3 point,
3.2 capital A within bracket C is furnishing of class 1 contractor registration certificate.
class 1A.
Yes, class 1 may not. Only class 1 is mentioned. That is page 26 of the petition.
Yes.
He did not furnish that initially. Then opportunity was given to him. Details panel will find the date is 13/10/2022. I've given all the details in my list of dates and the documents. Along with other bidders, the same opportunity petition also got. Otherwise, his bid would not have been techno-commercially responsible. He suppressed all this and only highlighted that I was given this opportunity as responsibility. Thereby, we not got the benefit of the interim order. So, interim order, the benefit of interim order was taken from the Honorable Court by suppressing the material fact. So, my lord, petitioner will not be entitled to relief, and for this, my lord, I am placing reliance on 2004 7 SCC, page 166. 2004 7 SCC, page 166. Relevant page 173.
2004.
2004 7 SCC, page 166. Relevant page 173, paragraph 13(1)(3). That is SGS Business Enterprise versus the state of Bihar. I read this paragraph, paragraph 13.
1-3.
1-3. 1-3. Party SGS Business Enterprise versus the state of Bihar. I'll read slowly. Para 13. As a general rule, suppression of material fact by a litigant disqualifies such litigant from obtaining any relief. This rule has been evolved out of the need of the courts to deter a litigant from abusing the process of court by deceiving it. But the suppressed fact must be a material one in the sense that had it not been suppressed, it would have had an effect on the merits of the case. It must be a matter which was material for the consideration of the court. Whatever view the court may have taken. Thus, when the liability to income tax was questioned by an applicant on the ground of her non-residence, the fact that she had purchased and was maintaining a house in the country was held to be a material fact, the suppression of which has entitled her to the relief claim. Again, when in earlier proceedings before this court, the appellant had undertaken that it would not carry on the manufacture of liquor at its distillery, and the proceedings before this court that concluded on that basis, a subsequent petition for renewal of the license to manufacture liquor at the same distillery before the High Court was held to have been initiated for oblique and material purposes, and the interim order passed by the High Court in such subsequent application was set aside by this court. Similarly, a challenge to an order fixing the price was rejected because the petitioners had suppressed the fact that an agreement had been entered into between the petitioners and the government relating to the fixation of price, and that the impugned order had been replaced by another order. So over here, my lord, the fact which was suppressed was a material fact. Had honorable court been told while moving the writ petition that the benefit which was extended to the respondent 6, similar benefit was extended to the writ petitioner also, and also to 5 other bidders, my lord would not have entertained possibly the writ petition. That was the only issue, my lord, in the writ petition. So therefore, my lord, petitioner should be held to be not entitled to any relief whatsoever. So, my lord, total 6 submissions I am making. I am formulating my submissions now. First, there has been a level playing field between petitioner and respondent 6. No preferential treatment to respondent 6, as opportunity was given to both and 4 others, to total 6 bidders. That's my first submission. Secondly, the bid of respondent 6 was substantially responsive, and there was no material deviation. Second is the bid of respondent 6 was substantially responsive and there was no material deviation. Either way, we interpret the clause 3 in whatever way we choose. Thirdly, the impugned decision is bona fide. It is in public interest, within the bound of reasonableness. The impugned decision is within the bound of reasonableness. There is no malafide, no arbitrariness, no irrationality, and no perversity. Most importantly, there is no intention to favor respondent 6. It cannot be said, my lord, of perusal of reports that there was any intention to favor respondent 6 over and above the others. That's my third argument. Fourthly, my lord, the questions raised on decision-making process do not constitute the ground for interference with the decision impugned. Because, my lord, the case laws I have already cited, there are case laws to their effect. The decision-making process should not be put to scrutiny. The decision-making process do not constitute the ground for interference with the decision impugned. Because in this case, in any case, there has been a level playing field. Nobody was given any preferential treatment. What is to be seen whether there was transparency or not? Fifthly, writ court should refrain from imposing its decision over the decision of the employer unless and until it finds that the decision is either very gross or there is something palpable is pointed out. That's the test. There is neither gross, nothing very palpable on the face of it. And lastly, we know the sixthly, the suppression of material fact. This entitling the petitioner to any relief. So, my lord, substantially, this is what my argument is in respect of this case. Because if not, the decision of the NHPC in respect of respondent 6 meets the law, the test of judicial scrutiny by this honorable court, this will have a bearing on the next case. So, my lord, I leave the next case, I will rather wait for judgment in this case. Because then, my lord, the work will be reduced substantially so far as the next case is concerned. Because the next case also, the respondent 6 is a party. And in the next case also, the respondent number 6, the bid of respondent number 6 being found techno-commercially responsive is under challenge on the same ground. Because if not, in this case, it is found that no, my bid was techno-commercially responsive and there was nothing wrong in accepting my bid, then will not this will have a bearing on the next case. So, we can rather wait for the outcome of this very particular case. I think.
Yes, anything in reply?
For a date or
No, because that will not be entertained.
part is concerned. The question that my Pranesh senior friend has raised in this particular case, that whether an opportunity was given to the petitioner also. But our case at the very inception was that whether that action is altogether permissible or not. And, because
Please repeat again.
not, but I should rather praise Milord because a senior counsel is engaged in this.
No, I understand, but the part and matter, you can't adjourn it.
My lord. And my lord, if I argue this matter, my lord, it will not be justified, my lord.
No, because you take a risk, because I'll otherwise close it. I will otherwise also close it. It's a part and matter, I can't keep it
My lord.
extended for any time.
Pranesh senior friend submit his give his submissions with regard to the second part, my lord. Will on the next day,
This
my
is
lord,
not arguing it. We'll be waiting for this judgment in this case.
my lord. Because both the methods are, my lord, related to each other.
It's okay, but he says that if this is decided, you have heard him. I did not repeat it.
Because my lord, that so far as this particular case is concerned, JLD, my lord, that part, my lord, Pranesh senior counsel, Mr. K. Chaudhary has already argued. My lord. Only, my lord, with regard to the second part. Today, my lord, the reply has been given with regard to the.
No, you see, I'm not adjoining it. I'm not keeping anything in my head. I already, what you call, it's burdening me. Keeping it parted, then it creates a burden. You understand it more.
Yes.
Then
So on this Thursday, my lord,
I'll close it. We can, at this, I'll give you an opportunity by tomorrow you file your written argument with copy to Mr. Tiwari, that's all.
and my lord, the second matter, my lord.
So you might, it's on the bar.
Petitioner is different. Issue and Milord, so far as the first case is concerned, JLD, the bid of JLD was found techno-commercially responsive and the bid of respondent number 6 was initially found not techno-commercially responsive and later on became techno-commercially responsive. That is a fact. So far as second case is concerned, in second case, Milord, it is the SIPL, a new writ petition is there. Now, in the case of SIPL, the SIPL was found initially techno-commercially responsive and subsequently found techno-commercially not responsive. So, my lord, that way are different. So far as eligibility of the JLD is concerned, the eligibility below, if that can be tested in the first case, the facts are not going to be different in the second case. I will deal with the SIPL part later on in the second case.
No, this, in item 5, who is the petitioner? Mr. Das, you are the petitioner.
My lord.
Then it's again for you to begin.
Second matter, my lord, this SIPL is the petition. First is the JLD.
No, in the second item, who is the petitioner?
Petitioner, my lord, this
No, I understand. I'm the counsel. Who is the counsel for the petitioner?
Mr. Ken Chaudhary is engaged in both the matters.
So, Mr. Das, that's what I'm asking you.
No.
You are the counsel to begin.
JLD.
Item 2, item 5.
My lord.
That is for you to begin.
Yes, sir.
So why would I ask Mr. Tiwari to start his argument?
My lord. Because my lord, my learned senior friend is insisting that he places arguments if necessary. That is why I'm putting my submissions like that.
No, I concluded the first part, so that is JLD case. I finished it.
On Thursday, my lord, the second.
No, I'm not taking up. We'll give you an opportunity to file a written argument by tomorrow. That's the best I can accommodate.
With regard to the
First item.
and the second item, my lord.
Second item will go. Whoever takes it, will take it up.
Once judgment comes in this case, it will be helpful in second case also.
No, I'm not concerned because
Either way.
if I'm taking up item 1, that item 2 will be released. I can not keep it parted.
At least one case will be over, So work can begin at least in one case. One way or the other.
Because why I'm submitting.
The issues are not similar, issues are different.
No, even if issues are similar,
Issues are similar so far as eligibility of JLD is concerned.
it's whether it's similar or not. That I'll say what has to be done. That is the matter.
Common judgment can be passed in 14 minutes.
Common will not be possible because SIPL stands on a different footing altogether. The
No,
bill
it's
of
okay.
JLD,
No. When I am not heard, I'll not decide what to do.
issues are not common. It's incorrect.
If I'm not heard, I'll not know what the issues are.
Only I'm seeking not 1 day's time, not so that.
You file a written argument. You see, I can't keep it parted. You see, I have assigned a different bench. I'm taking up criminal matters. And then to keep the matters parted and keep it refixing, there's something which it creates a difficulty. And for me, it's more difficult because once I have this criminal division bench, then to skip over and take up the writ petition, that to a tender matter. The amount of difficulty I face, you can't imagine.
Yes,
What is the difficulty? They can file it as argument now. The short time is given to them, they can do it. They can give me a copy. What is the necessity of?
I would not have had, my lord,
No, it's okay, but I
Very
will not keep it parted.
but my lord, because.
No, you see, how many days I can keep it parted? Please tell me, Mr. Das.
Earlier, my lord, this matter came up because.
I understand, but please tell me how much
How
much time I can keep it parted? How much time I can keep it parted? You know, you file it in argument, end of the matter. Why you need me to hear it? When you are giving the opportunity of having a written argument. No, something I have to close.
Both the matters are tagged together. That is why. And my lord, the parties should not suffer, my lord. They have, my lord, engage the senior counsel in this particular case.
But they will not survive. I'm giving them an opportunity of giving a written argument.
And some justice, my lord, because they have.
I've given you an opportunity.
Yes.
So, no further hearing. It's a parted matter, it takes precedence. If you don't argue, then we don't give you an opportunity.
What I find strange is they get the interim order, after interim order, the parties started.
No, I'm not
going
commenting.
over.
These are too
Very well.
personal. These are too personal. I'm
Very
not
well.
on that. I'm on the
I'm sorry.
issue. So this is not to examine the personal.
Today is Tuesday. If my lord will fix the matter.
I'm not keeping it for even for a moment. I'm not keeping it patterned. What will be over? I'm not keeping it patterned. I have my own reasons to do so. Mr. M.K. Das, the counsel for the petitioner, is present. the submissions of Mr. P.K. Tiwari, the senior counsel, assisted by Mr.
Yeah.
K.R. Gogoi,
AR.
A.R. Gogoi, A.R. Gogoi, counsel to the respondent number
6.
6 is concluded.
Oh, sorry, respondent 6 is a private party, NHPC. Sorry.
Yeah, respondent number, just tell me the respondent number.
2, 3, 4, and 5.
2, 3, 4, and 5 is concluded. The Learned Counsel to the petitioner submits that senior counsel Mr. K. M. Chaudhary will be arguing the matter for the petitioner in reply, for which he seeks a short adjournment, as the matter has been kept parted. Since 22/6/2023, the court has not been trying to adjourn the matter further. However, for enjoy justice, liberty is granted to the Learned Counsel to the petitioner to file written note of submission in reply by 10:30 a.m. to the court master on 10:30 a.m. on 31/8/2023. Next, civil accept granting opportunity to the petitioner, the Learned Counsel for the petitioner to submit argument in reply, comma. The case is reserved for judgment. Item 2. What says the duly represented? As argument in this petition is not even commenced, comma. This matter will not be treated as a parted matter. Just after a week.
Can it be on the same day?
I'm not fixing it. The first matter is closed. I'm just.
Second matter, because 31st is the date when we are supposed to file our.
No, it's not be listed. I'm saying you will file it before the court master. And reserved for judgment. Matter is reserved for judgment. We are just giving you an opportunity to file it before the court master. It will not be listed. Okay, this interim order passed stands extended to the next.
One.